open this public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Foreign Influence Transparency Scheme Act 2018. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. The hearing today is being conducted with both members of the committee and witnesses appearing in person and by video conference. I remind all witnesses that in giving evidence to the committee you are protected by parliamentary privilege unless you are giving evidence from outside Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of the 7th September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. So welcome, Ms Manstead. I now welcome you for you to give evidence to this public hearing today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee? We don't have any other witnesses at the moment besides Ms Manstead, is that right?
That's correct.
No, that's it. If you could just state your full name and the capacity in which you appear before the committee, please, Ms Manstead.
Thanks, Chair. I'm Catherine Manstead. I'm appearing in my personal capacity today, although my background lends my area of expertise to this subject. I'm a Senior Fellow at the ANU National Security College and the Director of Cyber Intelligence at CyberCX.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement, if you have one, before we proceed to a broader discussion.
Thanks, Chair and committee members. I will make brief opening remarks of this nature. Firstly, upfront acknowledge that the Foreign Influence Transparency Scheme FITS is a world-leading instrument for Australia, and it's something over the past 5 years that our peer democracies have been looking to and still are looking to as they craft their own policy, legal and operational responses to foreign interference. That said, there's a pressing need, in my view, to recalibrate FITS to ensure it remains fit for purpose. In part, that's because of two external drivers that weren't present back in 2017. One, that's that our strategic environment in Australia has deteriorated more rapidly than any government policy or strategy anticipated. And two, it's because our adversaries have been watching what we're doing and they are adapting to FITS in order to work their way around it. In particular, authoritarian governments find and exploit grey zones in our legal and policy responses, and they do that to subvert our democracy while not meeting the evidentiary and legal thresholds in a piece of legislation like FITS. But there are also three shortcomings in my mind that have been with FITS since its inception. They are, one, that it doesn't capture always the right information, which means it is capturing some low-risk, low-threat activity that actually distracts from its fundamental purpose of cataloguing and exposing foreign influence. But on the other hand, it has blind spots, particularly when it comes to capturing influence that emanates from authoritarian governments. Authoritarian influence, whether it is domestic or foreign, tends to be more complex, more informal, and often opaque, secret by nature, and that's something that our rule of law democracy sometimes hasn't been able to adapt to. The second shortcoming is that even where FITS is capturing the right information, it's not actually reaching the right audiences in a way that's meaningful and useful. We don't want FITS to become a compliance check-the-box mechanism. It needs to be a powerful transparency tool that is meaningful and used by the public and by decision makers across our democracy. It's worth noting that in 3 years, between 2018 and 2021, there are only about 10,000 visits to the register per year, and it would be almost certain that they are not unique visits. So it's not a well-used tool. And finally, the final shortcoming is that, frankly, FITS has a bit of an image problem. It's seen as a name and shame list. It's not seen as something that is a bulwark of democratic resilience to us. And partly that's because its enforcement regime is not appropriately graduated and calibrated, and partly that's because it doesn't capture the right information. So most of the media attention on FITS has focused on perceived failures to register as opposed to more holistic engagement about the trends, drivers and patterns of influence that FITS could be showing us. There are a range of recommendations that are before this committee that could address these problems, and I'll just briefly list them and then we can go into more detail at the committee's pleasure. But there are, in my mind, 4 areas of recommendation that need to be considered. The first is that we must ensure that FITS is a usable and used portal for citizens and decision makers across our democracy. 2, we need to improve the quality of information that is on the register by improving enforcement mechanisms and resourcing a regulator that is more responsive and intelligence-led. 3, we should update FITS to reflect the reality that risk from authoritarian governments is different to the nature of foreign influence and the risk of influence that comes from democratic countries. And finally, it may be useful for the committee to consider whether the Attorney-General's Department is in fact the appropriate body to continue to administer FITS as it moves into its next phase.
Thank you so much, Ms Manstead. I might start off with a couple of questions, if that's okay. That was a really good summary. Let me start with from the back and move backwards into the beginning of your introduction. But certainly at the end there, where you talk about the recommendations, one that struck me to start off with was this question around updating FITS to be more, I guess, in touch with the way that authoritarian governments interfere or try to influence versus democracies. In that recommendation that you're suggesting there or discussing, are you going so far as to remove the country agnostic, I guess, element of the scheme towards a more country specific arrangement?
Well, I think this is an area where reasonable minds are going to differ over the course of today. In my view, the fact that FITS is country agnostic as a general proposition is actually a good thing, because it's not a naughty list, it's not a name and shame list. It is a way to gain transparency across all acts of foreign influence in our country. But where it falls short is the legal definitions. The evidentiary thresholds don't take into account that influence that emanates from authoritarian governments looks different to influence that we see within our own democracy and that comes from peer democracies around the world. So I would support, in the Attorney-General Department's submission, I would support the ways in which they propose expanding the definitions in legislation to capture a broader set of activities and relationships. But I would also urge the committee, as you think about that, not to resist the temptation to codify everything in legislation. I think it would be unfortunate if we put everything in it in legislation and don't leave space for the oversight body for FITS to issue guidance from time to time that is responsive to how governments adapt to FITS, that is responsive to changes in patterns of influence, and is responsive in particular to intelligence coming from elsewhere within the government. So what I would like to see is a broad legal framework that permits the Attorney-General's Department, or whichever agency or department is administering FITS, to issue binding guidance, and in some cases non-binding guidance, that helps to break down and helps us to understand where there are acts of influence that might currently be flying under the radar.
So that's really interesting. So not be prescriptive about being country specific, but what you're really talking about, and this is a kind of a drafting challenge as well, whether it's drafting or amendments or whether it's guidance and the regulatory sort of framework around it, basically highlight that the scheme does have to treat authoritarian countries and their activities differently than democratic countries, and there's going to be all sorts of argument back and forth about how you define that. Does that include illiberal democracies as well? Who does it include? Which countries does it include, and what activities? But you're basically suggesting that the scheme should really treat those two types of influence differently because the intent presumably is different.
Look, I think it just needs to recognise that influence in authoritarian countries looks different, and it's more secretive and it's more complex often. That doesn't mean that we need to have a list of authoritarian countries even. It doesn't even mean that we need to list out what we think is an authoritarian regime or an illiberal regime, but it means that we need to have guidance that says, for example, if a company that is not a foreign government related entity on the current test has embedded within it representatives of the ruling party of a government, which is a common feature in authoritarian regimes, then it is automatically treated as a foreign entity that needs to go on the list. Or if there are members of the ruling party who sit on the board of a company, well, then that should be captured. So I don't think we need to kind of go through the extra difficult work of conceptualising what's authoritarian, what's illiberal. We just need to recognise that different countries go about their political system differently. Some are more closed, some are more secretive, some have ruling parties as opposed to elected officials, and we need to make sure that that is captured in how the scheme is enforced and administered.
Yeah. You've written a very good article around the domestic security grey zone, that space between foreign influence and foreign interference as they're sort of currently defined. Could you talk us through, or the committee just explain what you mean by that grey zone and give some examples of where influencing activities start to move into that grey zone towards interference? And does it have a lot to do with what we've just been talking about, which is where it's actually coming from? Which regime or state is it coming from? Does that determine whether it sort of trips into the grey zone and then into interference, for example?
Yeah, so I think up front, the first thing to acknowledge is that political influence in authoritarian countries, whether over their own system or whether over ours, is by nature more controlled. Because that is the nature of authoritarian regimes. So that means that who can influence, how they can influence, and what topics they're able to have political views and political power over is different. It also means that that relationship between state and market, when it comes to an authoritarian country, is different because there is generally a coupling between state and market, whether that's informal or whether that's required by law. So that's the backdrop. Then let's take it down to this grey zone. We know that in particular for some authoritarian governments, not all, but some, particularly China, Russia and Iran, the way they go about doing their business when it comes to influence or interference in democratic countries is they look for loopholes and grey zones to exploit. Those grey zones are actually created by us. However we calibrate our legal regime, those who wish to subvert our democracy will find ways around it. We've seen that really starkly outside of this problem set in the military strategic zone. So we could think about the way in which China engages in salami slicing in the South China Sea to advance its territorial aims while also avoiding thresholds under international law. Russia's also a master of that craft. The same thing applies when it comes to protecting our democracy from malign influence, including foreign interference, where we see authoritarian governments deliberately playing in that grey zone between welcome influence and foreign interference. A good example of that is the way in which, for example, a number of activities coming out of the Chinese Communist Party aren't captured by either foreign interference or even the foreign influence register. We could think about the way in which there is no United Front work activities currently captured on the register. Another example is the way in which we've seen some organisations change their governance structure to avoid being put on the foreign interference transparency register, for example, by adding extra layers of complexity to their governance regime. by hiding relationships
Yep.
so that it's almost impossible for the organisation in Australia to do the due diligence to understand what's going on. That's the problems that we're dealing with, and we know that interference and influence is one of the key strategies of some of those authoritarian governments. So they're going to do it more and more and more, which is why not only do we need to update what FITS captures, but in my view, we need to do it in a way that is flexible, responsive, and intelligence informed. Because if we just adapt all our legal definitions, set and forget and move on, well, our authoritarian regimes who wish to do us harm will find new grey zones and loopholes to exploit.
Now, thank you, Ms Manstead. A lot of colleagues, committee members have questions, and we've got half an hour, which is great. I have one last quick one, and it's been sort of on my mind a bit in looking at all the evidence, and be interesting to get your insight. You sort of touched on it a bit, but given what you've said about the way that authoritarian states operate, the way they do influence and towards interference and so on, just given that intent, that first principle of this scheme, which is to shine a light and increase transparency, is predicated on people, individuals, others registering. And if you're authoritarian state doing everything you can to avoid registering, to avoid even showing, highlighting or even revealing anything that you're doing, how does the scheme work when it doesn't capture? You're not going to get that voluntary registration of activities from those groups by the very nature of the intention of their activities. They're not going to go there. They're going to try and avoid that as much as possible. So isn't that a basic flaw in the premise of the scheme?
So obviously, where you've got influence coming from opaque regimes, and the regime and our scheme depends on self-reporting, obviously that's going to be challenging for something that's about transparency. But I think there are some things we can do. One might be to create certain presumptions, and this I think should come at the guidance level, not at a legislative level, but presumptions that where the counterpart that you're dealing with overseas has, for instance, an embed from the ruling party in that corporation, well, then it should be presumed to be something that goes on the register. Or where we know that there is a particular law in a country, say China's national intelligence law, that requires a certain level of collaboration for some companies and sectors that is also required to be secret, that may also give rise to a presumption that engagements with organisations affected by that law are also captured by the register. So there's ways for us to pierce that veil of opacity, if you will, by how we set the scheme up. And that means we're going to have to move a little bit away from some of the strict evidentiary standards in the scheme because, of course, you cannot find evidence where it is deliberately concealed or just because it's different, because it's informal and unlikely to be caught. The second thing, and this is a recommendation in the Attorney General Department's submission, which I think is a good one, is to increase the powers available to the Secretary, in some cases to put organisations that should be on the register. So that's kind of giving powers to the Secretary short of formal legal proceedings. The problem in Australia and the good thing of legal proceedings in Australia is we have high evidentiary thresholds, and particularly for criminal proceedings, of course, we must prove things beyond reasonable doubt. That might not always be suitable where you're dealing with entities where you can't gather information or that information is being deliberately concealed. So we need powers short of a criminal proceeding to deal with that, put it on the register.
Thanks, Ms Manstead. Yeah, no, thank you. That really is helpful. Given time, I want to go. I've got Senator Patterson, Senator Smith have indicated they have questions, but as is protocol, I should just check with the Deputy Chair if he has a question before we go to the other members.
Yes, thanks, Chair. I do have some questions. Thank you. Thanks very much, Ms Manstead. The FITS was modelled on FARA, on the US legislation. Now, my understanding is that the original bill, the FITS bill, was much narrower in its scope, having been modelled on FARA. What happened, are you aware or can you speak to what happened from a legislative perspective in Australia to see a lot of the broadening of the FITS?
I'll give a partial answer to that, Deputy Chair, because my understanding is that in some respects FARA is broader because it captures we've quite narrowed down the definition of foreign government-related entity and the control tests related to that. And there are actually maybe more things that get caught up on FARA. I know, again, in the Attorney-General's Department's submission, they have two options for the committee to consider, kind of going to a let's catch everything FARA model, or a model that helps us capture some of those pernicious authoritarian influence acts we're talking about. I'm in favour of the second, because I think if we suddenly capture everything, then the register doesn't meet its purpose, which is providing meaningful information to the public and to the agents of our democracy to make better decisions. I like to think of FITS as a democratised form of intelligence. It's something that community leaders, business organisations, the media, everyday citizens should be able to look at to inform their decision making. So that means it needs to be, like government intelligence is, relevant, actionable, timely, and contextualised. So I would always be in favour of something that narrows the scope and makes it more meaningful than something that is more broad brush and ends up catching everything, and also, frankly, increases the compliance burden on the very parts of our democracy we're trying to protect, rather than increasing the costs to authoritarian governments or others that would do our democracy harm.
So there's a bit of a wicked problem there, isn't there? On the one hand, you're saying you'd prefer a narrower version, but then you're saying on the other hand earlier that you don't think it should be codified. So how do you walk that fine line?
Well, I think we can set up a legislative framework, and we already have one, so amend it so that we have the ability for whoever is administering the scheme to be able to issue guidance from time to time that clarifies issues. We should also, within the scheme, amend some of the really strict definitions in there, for example, around the control test for foreign government-related entity. That's a really strict test at the moment. We could stand to pare that back a little bit. But a lot of the other things I was talking about, for example, where presumptions where there is a ruling party embedded in an organisation, I think that's probably going a little bit too far to start encoding all that in legislation. Then we end up with something that is unwieldy and ugly and not really consistent with how we like to draft laws in this country. It's better to push that to a regulator who can be more responsive, who can engage in more outreach with affected entities, and can change that guidance from time to time as the intelligence changes and as the laws and the legal regime in countries around the world also changes.
Thanks, Ms Vanstead. Given that this is your particular area of specialty, are you able to give the committee some sage advice on what the other jurisdictions that are looking at their own version of FITS as to what, Canada, the UK, if there are any other countries, for instance, New Zealand as part of the Five Eyes, what they're saying about the utility of the current FITS?
I can again give a partial answer to that because my expertise is the Australian approach. I'm less of a comparativist, but a couple of observations. One, for this committee, I think if we look over to what's happening in Canada at the moment, then the key piece of advice I would give is to avoid letting this discussion become politicised, because that is exactly what our adversaries want. So anything that we can do to ensure that this is bipartisan and that where there is difference, as there must be, it is not politicised, that is important. The second is if we look to what the UK is doing, they have been informed a lot by FITS, and they've formed the view that some of those things I was talking about before, for instance, lowering the threshold for control, is something that they will pursue, and I think that's a very good suggestion for us to pursue. And then the third thing is the US example. The US has had a regime like ours for a lot longer. I would say in general, it falls into some of the pitfalls that we have. It captures too much for it to be totally usable, meaningful and contextualised, and it doesn't always push that information out across society in a way that it should, so that we can inform decision-making, can inform behaviour across our democracy, rather than just collecting information in another kind of compliance exercise that may not actually build our democratic resilience.
Last question, Chair.
Thanks. Yes,
question.
thanks, Mr. Wallace. We've got thank other members. Last question, is it?
Yep.
Cheers.
The Attorney General's Department, in its original submissions, talked about a graduation or the introduction of a graduating form of penalties but then in their second submission walked back from the concept of infringement notices. I'm wondering if you've got a view on that.
I'll leave the lawyers to, so I think it was a legalistic reason why they didn't want an infringement notice. I think I'll leave the lawyers to hash that one out. What I would say is that it's almost a no-brainer that we need a more graduated set of enforcement powers, because it's not enough to go from zero to hero of nothing to criminal proceedings. That's just not sufficient. I also think that there is a role for what the AGD talks about, the Secretary's power to add people to the register or to kind of put them on a list if they think they should be on the register. I also think there's possibly scope below that for more guidance, more advisories put out from the Attorney General's Department, like our corporate regulators do, for example, kind of class rulings, guidance documents to help clarify how FITS applies and to do some of that work we were talking about before to make sure that it is adjusted from time to time to how our those countries influencing Australia change their practices and behaviours.
Thanks, Chair. Thanks,
Thank
Ms.
you.
Manstead.
Thank you. Thank you, Deputy Chair. I'll go to Senator Smith, who has a question.
Thanks, Chair, and thank you, Ms Manstead, for your evidence today. In your opening remarks at the end of your statement, you posed the question as to whether the Attorney General's Department was the appropriate body to manage the scheme. But then as we've had this discussion, you've sort of made some comments about what that department could be doing better or differently. So I just wanted to clarify with you sort of what your view of best practice would be in terms of the management of the scheme. Is it the Attorney General's? If not, who? And within the sort of way we've got it set up, what you'd like to see.
Yeah, so this is one where I don't have a firm view, but I have some ideas. One is you would have noted that what I think is really important about this scheme is that it is something that is public facing and that it is engaged with. And frankly, that is not happening at the moment. There is no one who is really engaging with FITS. And that might be because it's sitting inside a relatively cloistered part of the government. I put in my paper that I referred to in my submission the idea of a sovereignty commissioner, for instance, an independent post who is empowered and trusted to speak with the Australian public about trends in foreign influence. Remembering that the whole idea of the foreign influence scheme is not just to catch bad behaviour we don't like, but also to baseline and explain every year what the shape, the size and the trends of foreign influence is, because often that foreign influence is a good thing. So I think there is merit in continuing to consider whether there is an independent voice on this. I also think even if we leave it or the committee decides to recommend leaving it within the Attorney General's Department, there is a need for much more intelligence sharing and interdepartmental collaboration between Home Affairs and the Attorney General's Department. And I also think it's worth considering recommendations from, for instance, the G08, who say that the compliance burden for them is extreme. The outreach from different parts of government on a range of different security and intelligence matters is difficult for them to keep track of. Perhaps there's merit in having a central coordinating point in Home Affairs that can speak to critical infrastructure providers, institutions of our democracy at large, along a range of these risks to provide them advisories, advice, latest risk, and also advice on how they should comply with what is a growing number of security-related bits of legislation.
Thank you. And just one more question, Chair. In terms of that, your proposed model around a commissioner, are you aware of that happening in any other jurisdiction, or is that something which would be a first for us if we were to go down a path of that recommendation?
I'm not aware of it happening anywhere else, but Australia's always led on this front, so I don't see why we shouldn't be pioneers here. The example I would draw within our own system is the way in which for the kind of the pointy end of influence, foreign interference, we have now a much more public-facing role for the Director General of ASIO, who every year does his annual report and address and speaks about examples of foreign interference. In my mind, we need the equivalent that speaks about foreign influence, much of which is welcome, some of which is unwelcome, and can do that in an independent and trusted way, not in a politicised way, and gets that cut through and outreach to communities and industry across Australia.
Okay. Chair, if there's time at the end, I've got one more, but happy for you to share the call.
Thank you, Senator Smith. Senator Patterson.
Thank you, Chair, and thank you, Ms Manstead. Your evidence has been very helpful so far. I want to come back to a couple of issues you've addressed in previous questions and just delve into them a little bit more detail. I'm particularly interested in your observation about businesses who are operating in authoritarian countries and whether or not we should think of them as private businesses. For example, you mentioned in China that the Chinese Communist Party often has a representative on the boards of some companies, and even in companies where it doesn't, it also often has Chinese Communist Party cells which operate within the company. In your view, should we treat companies like that as if they are private businesses or not?
No.
And why not?
This goes back to our discussion before. They're not independent in the same way as they would be within a democracy or a rule of law democracy, quite simply for the reason of that close nexus to the ruling party. And also that close relationship in authoritarian regimes, particularly China, between market and state, especially in certain strategic industries and strategic sectors and certain champion companies. In my mind, it's a no-brainer that those are not independent private entities as they would be if they were operating in a peer democracy like Japan, the US or the UK.
And as you pointed out in a comment in response to a previous question, even when they don't have someone formally on their board or on their committee, they're all subject to, for example, China's national intelligence law, which requires kind of cooperation with China's intelligence agencies. So in your view, we should regard any company which is subject to laws like that effectively as being a foreign agent for the purposes of this legislation?
Yes, I think that would be a very meritorious consideration for the committee. And the other point as well is that the way political relationships work in many of those authoritarian countries is that they are more informal, so they're not documented. And that also means that the current tests that we have, assuming ostensibly that every country in the world is a carbon copy of Australia and its peers, they don't work for different countries with different political systems.
Yes, and this has led to a current situation where under the current drafting of FITS, a company like Huawei is not captured by the Act, but it's kind of a pretty absurd proposition to say that Huawei is an independent private company operating at arm's length from the Chinese state, isn't it?
I agree with that proposition, and I would go one further to say that the way FITS is at the moment, it might be capturing a former minister on a BBC cooking show, but not capturing former politicians with dealings with a company like Huawei.
Very well said. We're in agreement on that. You also mentioned that authoritarian states are sophisticated in the way how they approach us. They change their behaviour in response to legislation that we introduce. I think one interesting case study for us to consider here is Confucius Institutes. When this legislation was introduced, Confucius Institutes had relationships between Australian universities and a body called HANBAN, which is a government entity, which was the coordinating body for all Confucius Institutes overseas. Since this legislation came into effect, HANBAN is now no longer the counterparty for Confucius Institutes in Australia. Instead, they've gone to having bilateral relationships with Chinese universities. Now, I don't know whether it was their intent to evade this particular piece of legislation, but it has had that legal effect because AGD has provided advice to universities that Confucius Institutes are not captured. Is there any plausible scenario where Confucius Institutes are not a tool of Chinese statecraft?
I'll leave others coming before the committee today who are experts in that area to furnish their view. I would just offer two more general remarks. One is, if organisations change their behaviour to not be on FITS, that could be a good thing because maybe it means that they are, in fact, operating at arm's length. However, it may very well be the case that organisations adapt their governance structure in order to avoid FITS because they intend to engage in influence. We should keep our mind open to both possibilities, and I'll leave others coming before this committee to provide a conclusive view on Confucius Institutes.
Thank you. Yes, I might raise that with Mr Joske, who is an expert in these matters. I was interested in your observation that perhaps more guidance is needed from AGD for compliance, and I can certainly anticipate that there are some people out there who are genuinely ignorant about their obligations and don't realise that they are captured by the scheme. But I have a pretty strong suspicion that there are others out there who know very well that they're supposed to register with this scheme and are deliberately choosing not to. And to cite one example, the Australia Council for the Promotion of the Peaceful Reunification of China is very clearly a United Front Work Department entity. It is directed by the Chinese state and Chinese intelligence agencies. No one would really contest that, and they have chosen not to register. And so far, the Attorney General's Department has not been successful in getting them or any other United Front organisation to register. Clearly, in cases like that, it's not an absence of guidance that's the problem. It's more the lack of enforcement powers, isn't it?
It's the lack of enforcement powers and a lack of graduated enforcement powers that may be a candidate for the Secretary to say, we will register you, even if criminal prosecution isn't proceeded with. And I think that's the problem with FITS at the moment. You really have a binary choice: do nothing, or go to the level of a criminal prosecution, which raises a whole bunch of issues around meeting standards of evidence and so forth, and resources.
Yeah, agreed. Just moving on to the right body to enforce this and the kind of just how prescriptive we should get in the legislation. I generally agree with your proposition that we should avoid becoming too prescriptive. We should grant some flexibility for agencies that have to actually enforce this. But the Foreign Influence Transparency Scheme has now been in place for 4 years. The Attorney General's Department has had coverage of that this entire time. And no less an authority on the intent or the objectives of the Act than Malcolm Turnbull has said it has failed. Do you really think that AGD can be left to their own devices to do this? Or do we need to be much more prescriptive with them about what we intend for them to do and perhaps how much resources they have to do it with?
Look, I'll tackle it from the resourcing end. It's famously not a well-resourced part of the Attorney General's Department. And also, it is a piece of legislation that creates compliance requirements. And like any piece of legislation with a compliance requirement, organisations and entities will take a compliance approach, right? It's a bit like the old saying about anyone who's doing tax will try and minimise their tax, even if they don't try and tax avoid. When it comes to organisations being on the register, I think a similar approach is being taken. If you can, through the legalistic approaches to it, avoid being registered, organisations do. So I think that is where we need to make sure that FITS is updated to make it less of a check the box or a legalistic approach, and one that is more geared towards getting organisations on there. Part of that is actually addressing the image problem I mentioned before. It's not a name and shame list. And that's also why I'm not in favour of throwing the country agnostic baby out with the bathwater. But the other thing is having a better resourced regulator with more outreach, with more guidance power, with more access to intelligence from across the rest of the government, so that they are able to more proactively get people on the register or entities on the register that need to be there.
Yes, thank you. And just a final comment on that issue, Chair, and then I yield the call to any other colleagues. I'll seek confirmation from the Attorney General's Department in their evidence this afternoon when they appear before the committee, but it is my understanding that it is a very small team which is working on this, and it doesn't surprise me that the enforcement outcomes haven't flowed, given that such a small number of people who have other things to do in their daily lives are tasked with enforcing it.
Thank you, Senator Patterson. Are there any other questions, or can I go to Senator Smith? Mr. Wilson.
Thank you, Chair, and thank you, Ms Manstead. I just want to pick up a couple of points that you made. I mean, everyone seems to agree, and in your submission, you've made the point that in many respects, as far as increasing transparency, awareness and data sets, etc., FITS has largely been unsuccessful. You also talk about the danger, I guess, in something like FITS effectively having this kind of blacklist characterisation attached to it, and then possibly really increasing xenophobia and polarisation and distrust in our system. And then towards the end, when you're making your recommendations, you say that one of the ways of addressing presumably the apparent failure is to make it more wide-ranging, more fine-grained, lower the threshold, and so on. I'm just interested in your sense of the balance of those things. I mean, clearly it hasn't been doing the job it was supposed to do. So one way of addressing that is to make it operate more widely, bring more people into it, lower the threshold. It would seem to me, though, that that goes to the other risk that you mentioned, that in effect it increases that sort of inquisitorial, internal self-reporting aspect where everybody's looking at everybody else, trying to find things that perhaps aren't really matters of concern, and that really only just achieve perhaps the purpose of some outside actors in exacerbating polarisation, distrust and democratic dysfunction?
2 points to that. The first is, I think transparency in a democracy is always good. But the second point is that it's just a matter of common sense that we recognise that different countries do influence differently. That's not necessarily bad, but that is a common sense understanding that in often authoritarian countries, the way that political influence happens is different. And so a legal regime like FITS that's captured that's drafted to imagine that every country looks like Australia is just not going to work. It's not a bad thing automatically to say that some of these activities in authoritarian countries are happening. It's just a reality. And FITS needs to show a realistic picture of influence across our democracy. And just being on FITS doesn't mean that that influence is unwelcome, but it does mean that it is being subject to transparency, which is democracy's magic weapon, frankly, against polarisation, against interference and all of these other harms we're trying to protect against.
Well, yeah, I mean, I accept that. Well, so far FITS isn't working. So far FITS is not showing us the things that we are being told is happening and is there. So I guess we change FITS so that it finds us these things that aren't there. But I mean, I guess your point itself, you can't. The idea that all transparency is good. There are limits. I mean, there's issues like personal privacy, the surveillance state, and all of these things. I mean, arguably, people coming into one another's houses or going through one another's phone calls. These are all forms of transparency. They're not forms of transparency that we think are helpful or healthy in our kind of democracy. So I'm just asking you. We've got a scheme. It's not working. It's not showing us the things that we believe might be there. And part of your answer, well, you've got two things. One is look further and harder, bring more people in, lower the threshold, cover more entities, create more bureaucratic requirements. At the same time, militate against the extent to which this creates an atmosphere of xenophobia, an atmosphere of everyone looking at everyone else and perhaps reporting on everyone else. How do we get that right?
So I think I'll let what I said before stand, and I'll add one other thing to what I said, which is foreign influence has always been something that democracies regulate. And that is different to ordinary influence and ordinary political dealings. And I'm not suggesting for a moment that domestic influence and domestic political undertakings should be subject to the levels of scrutiny that you're perhaps alluding to there. But foreign influence is something that we have a view on in democracies. It's why members of the place that we are in virtually came a cropper with sections of the Constitution around dual citizenship. We have, across a range of different bits of our constitution and our legal and our policy framework, a different approach to foreign influence than we do domestic influence, and that's to protect the sanctity of our democracy. So I do think there is there is a need for extra scrutiny and extra transparency to be applied to foreign influence that is targeting our democratic polity. Not all of that influence is bad. A lot of it is welcome, but there will be parts of influence that are not welcome, and having a scheme like FITS that is calibrated and not just collecting everything out there can help us to understand that and push back.
Thank you, Ms Manstead. Thank you, Mr Wilson. Thank you for your attendance today. We're right on 11:30. It's perfect timing. Ms Manstead, if you've been asked to provide any additional information of answers to questions on notice, the Secretariat will be in touch regarding timeframes for providing that to the committee. You will be sent a copy of the transcript of your evidence once it is available in the coming week, and you will have an opportunity to request corrections to transcription errors if there are any. So thank you very much again for your participation today. Much appreciated.
Thank you, Chair.
I will now, colleagues, welcome the next group of witnesses. I now welcome Professor George Williams, the Deputy Vice-Chancellor of the University of New South Wales, Dr John Byron, Principal Policy Advisor QU2, Queensland University of Technology, is that right? QU2. Appearing for Universities Australia, Mr. Peter Chesworth, Deputy Chief Executive, Mr. John Wellard, Policy Director, International and Security. Appearing for ATN, Mr. Luke Sheehy, Executive Director. For the Group of 8, Ms. Vicky Thompson, Chief Executive. And for the University of Melbourne, Mr. Michael Wesley, the Deputy Vice-Chancellor. I think many of them are either online or in the room in Canberra. Thank you. For the Hansard record, well, I've just sort of done it, but could you each please state your full name and the capacity in which you appear before the committee, just for the record?
I'll kick off. Vicky Thompson, Chief Executive of the Group of 8 Universities. John?
John Byron, Principal Policy Advisor, Queensland University of Technology.
Luke Sheehy, Executive Director of the Australian Technology Network of Universities.
Online, members and senators, Peter Chesworth, Deputy Chief Executive from Universities Australia.
John Wellard, Policy Director International at Universities Australia.
And George Williams, appearing on behalf of the University of New South Wales.
Is Mr. Wesley online?
I thought he was actually going to be here.
No, I don't think he is. But we do have Dr. John Byron online.
Yes. No, I'm in the room.
Yes. Yeah, you're in the room. Excellent. So we're missing Mr. Wesley. I'll just check with the Secretariat as to whether we are going to wait for him or whether we should just kick off.
No, Chair, please commence.
Okay, great. Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I'll go to invite you to make a brief opening statement if each of you have one before we proceed to discussion. But just on that, obviously we have about 45 minutes, so if everyone did a 5 to 10 minute statement, we'd eat it all up. So if you do have a brief opening statement, if you could do it in a minute or so, that'd be great. Vicky, why don't we start with you?
Thank you, Chair. I've tabled a statement to the committee, so I won't read it into the Hansard, But what I will just make perhaps a point which may actually seem very obvious to this committee, but I think it's worth making as we're discussing the Foreign Influence Bill, as a framing point, if you like, that we're looking at foreign influence, which is distinct from foreign interference. Influence, as we've heard from previous witnesses, is by its nature open, transparent and part of the normal diplomatic relations, and interference, as I know this committee knows well, in contrast, is clandestine, coercive, deceptive or corrupting. And FITS is looking at the influence part of the puzzle, and the reason I raise that is that I think that there is sometimes a conflation of the two issues and they are distinct. And I think it goes potentially to the grey area that I know you've discussed, Chair, in other forums. And we certainly do have other legislative tools to capture that interference side. And so certainly from my perspective as a member of the Foreign Interference Task Force, ever present in our minds is the very clear distinction between foreign influence and foreign interference. And I think that's where sometimes we are getting into some issues about the efficacy of the FITS bill in addressing foreign interference. So I'll just leave that there as a framing statement.
That's great. Mr. Wesley, welcome.
Thank you very much, Chair. Good to see you again. It's been a while.
Good to see you. It has been a while. I'm not sure if you heard the opening statement, but I might have the Secretary make sure you are aware of that. But we'll just move on to Dr. Byron, if you had a minute.
No opening statement, Chair, in the interest of time.
Thank you, Dr. Byron. Professor Williams?
Thank you, Chair. I do have a short opening statement, and I'd start by saying that at the university we recognise the value of the legislation and the need to properly regulate foreign influence through a transparent scheme. So we are on board with the legislative objective underlying the legislation. But I want to make 3 points about how this particular legislation misfires and doesn't actually achieve its objectives in what I see as a reasonable way. The first is it's just not clear legislation. It lacks clarity in key areas. It's a maze of vague definitions and language that makes it very difficult to apply. And that gets in the way of people understanding their obligations, let alone actually complying with them appropriately. The second thing that is a problem is that it's badly calibrated to actually achieve the objectives in this area. In one sense, it covers too much, but it also covers too little. Too much in that you are looking for the registration of issues that simply pose no known security risk to Australia, with countries that don't raise issues that would concern us, and so the registration of those activities don't serve any compelling or necessary public interest criterion. But secondly, when you look at the actual items that have been registered, it's not clear we're actually capturing the higher matters of foreign influence that we might expect to be covered. And so that over-inclusion and under-inclusion suggests a scheme that's not well drafted to achieve its goals. And the third point is that we do have a very positive example, as this committee identified in its first recommendation on its report on the higher education sector. That's the UFIT process. It talks there about active transparency, and it's not clear how this scheme fits with that process. It should be something that's well integrated with other schemes. It should be part of a larger body of work. And at the university sector, we'd like to clearly know what we need to do to support the national interest. And again, to be frank, it's just not clear where this scheme fits and what's it trying to achieve when it comes to our work. Thank you.
Thank you, Professor Williams. Mr Chesworth and Mr Weller, do you have a joint statement there for...
Thank you, Chair, Senators and Members. Do not have an opening statement. We provided a submission other than to say that we support everything that Ms Thompson said in her opening statement, and also Professor Williams. I think particularly the point that FITS forms part of a broader mosaic of regulations and activities in this area to which universities are keen to participate in. We will respond to whatever legislative and regulatory framework that is presented to us. We do appreciate the opportunity to be involved in the amendment and design and improvement of it. And that's all. Thank you very much.
Thank you very much. Mr Shi?
Thank you, Chair, and thank you, Committee, for the opportunity. I have tabled my opening statement. I'll give a brief few remarks to provide an overview. The ATN universities, and now the University of Newcastle is a member, so we can include them in our group, acknowledge the growing area of importance of protecting Australia's national security interests and the emerging areas of regulation that have been put in place over the last number of years, but emphasise the fact that there have been a number of different schemes operated through a number of different government departments. That does spread the expertise across government very thin. That said, at the same time, our universities have increased our cultural awareness of these matters and have improved significantly over this period. And we emphasise, particularly with UFIT process, where the co-design is with the sector and the government and security agencies, is best practice.
Thank you, Mr Shi. Professor Wesley, do you have a minute or so opening statement? If you...
Thank you, Chair. Look, I would just say that I support what Professor Williams said. I wasn't here for Ms Thompson's remarks, but I'm sure I support that wholesomely, as fulsomely as well. The one point I would add to what my colleagues have said is that it's terrific to see the review of this particular act. But what I would urge the committee to do is to review the whole range of foreign influence, foreign interference, regulations and legislation at the same time. As someone who has led my university's response to each of these, it is not clear to me that we have a coherent and mutually supporting regime of instruments for dealing with foreign transparency and foreign interference issues. From where I stand, I think a good review would see areas of overlap, areas of redundancy, areas of ineffectiveness, and quite frankly, gaps. I'm not sure that when these pieces of legislation and regulation were being put together There was much thought given to how they articulated with each other, and I think they are ripe for a comprehensive review in the coming years and coming months. Thank you.
Thank you, Professor Wesley. I might kick off with the first question and just plucking out two themes, I guess, that were quite prominent in the submissions that you've all put in. First, I wonder if those who wish to could comment on this issue around duplication of the FITs with, for example, the foreign arrangement scheme or any other elements of the broader CFI framework that Professor Wesley just alluded to. Where are those duplications? How much bureaucratic and administrative burden is it putting on the university sector? Be interested to hear comments and the concerns around that, if you could sort of go into that. And the second kind of thing to pluck out is this, I think Professor Williams articulated in his opening statement about the breadth without the depth, as it were. You know, it's very, very wide. It covers quite a lot of ground, but then doesn't go quite deep into where it needs to. So it kind of captures things like BBC interviews, but not, you know, the stuff we should be capturing. And I'd be really interested to hear how that pertains to the university sector. Is it, and this is obviously connected to the first part of my question, it's not just duplication. There are gaps, as you've highlighted. So those two themes, duplication with the foreign arrangement scheme or any other elements of the regulatory framework, can you comment on that and how it affects your universities? And then the second part, which is how do you address this breadth but no depth question that was raised?
Chair, just to save...
Who would like to go first?
Chair, just to save some time, I wonder if I can just butt in there for a second and just ask the witnesses to also address the University Foreign Interference Task Force and where that fits in.
UFITs, yep. Yeah, good. Thank you very much for that, Deputy Chair. If you could address the UFITs as well in the context of that broader regulatory framework.
So, Chair, maybe I can jump in very quickly. We've done a quick audit. A lot of these are sunk costs. The University of Melbourne we have estimated that we have, for the foreign arrangement scheme, the cost in compliance from all sources was well over $1 million to put those systems in place. Those systems are now, we are confident that they're robust. The cost to us for implementing a disclosure platform, foreign engagements disclosure platform, was also over $1 million, and that is now in place, and we're very confident of the robustness of that. What is a little bit puzzling, I must say, is that we believe we've been fully compliant, and I think colleagues across the sector, we share experiences and we have a fairly good visibility across the sector on what we've all done. There's been no follow-up from government about our compliance. No one has come and looked at our systems. No one has expressed any interest in our systems. And so I think it's almost as if we were asked to do things and we were kind of trusted to go ahead and do them. We would like to see a more robust government response in a way of partnership, to be honest, to actually work with us to share best practice across the sector, to feedback on what government believes is a robust system and what needs to be tuned up. We've had absolute silence, I'm afraid.
So, are you doubling up on the regulatory requirements? Have you noticed that you are having to do the same sort of compliance for different parts of the framework, the regime?
Yes, that's right. And quite often, you know, we can use processes and structures that we put in place for a previous set of requirements to comply with other requirements with some tweaks. But there are new builds that we are developing all the time. And I think also the one kind of set of positive synergies is that we could say, certainly at the University of Melbourne, and I would say across the sector, that the level of staff awareness and information about foreign interference threats has risen remarkably over the last four years or so.
Thanks, Professor Wesley.
And I might just pick up on a couple of those points, if I may, very briefly, Chair. You're looking at a group of universities that does 70% of Australia's university-based research, so there's a fairly concentrated effort in a small group of universities. This piece of legislation was introduced and implemented before UFIT, to your question about the University Foreign Interference Task Force. It was an early piece of the puzzle, if you like, but I think we have a far more sophisticated discussion now underway as a result of the University Foreign Interference Task Force. And not to put all the eggs in the UFIT basket, of course there are a range of other compliance issues that we need to be dealing with, but I think it's a really good opportunity to use that as a almost like a sounding board and a testing board, if you like. I know we've made recommendations and others have in their submissions about pulling this together, and Professor Wesley's final point in his opening statement was about some sort of a review process. I think that you can have this iterative process because foreign interference and foreign influence is not, job done. It is actually something that we need to keep constantly on. And I'll just leave you with one anecdote from one of my universities that raised an issue with me about having discovered an issue of potential foreign influence. What do we do with that now? Who would want to know? And when we actually approached the agencies, I did on their behalf, the answer back was, well, no, we don't need to know about it. We just need to know that you know about it. And so I guess in one sense you can say, well, that there's a level of trust there and that's a good thing. But there is also a need, I think, for a greater level of, as Professor Wesley said, of that kind of dialogue between the agencies and the universities.
Just on that, did they expect you, there was no guidance back as far as instruction about what to do about that?
No.
That circumstance?
Not as I understand it.
So the university used their own judgment and did what they did? Was it Professor Williams or someone else had a hand up?
Yeah, I'm happy to go next. Thank you, Chair. And I think what is clear is that UFIT is working well, and even though we may be critical of this particular scheme, we have an arrangement which is proving highly effective. And I can say at our end, it's changing behaviour. It has had a significant impact upon changing our systems to identify risks. It's educating academics about the risks and how to navigate those. And I think we're seeing quite rapid increases in maturity at our university, as we're also seeing through the sector. And that's due to that collaborative arrangement. And we really say a big thank you to the agencies as well who participate in that. It has made a difference. We would certainly like to see more support from government in some areas to assess risk and to know what to do when we come up with some of these matters. So that's working. And we're looking back now with hindsight at FITS, which was passed in a different era, pre this arrangement. And I would put that and also the foreign arrangements legislation in the basket of high compliance, little impact. To be frank, there's a lot of work at our end, but it's actually not driving productive behaviour. And that's the problem. We want to use our resources well to actually drive behaviour that benefits the national interest, supports our academics and mitigates the risk. When it comes to FITS, we're actually at a loss sometimes to actually work out what it's meant to achieve in the sector. We're usually not caught by it in any event. Even Confucius Institutes are typically not caught by this. So we're actually not sure what it's trying to achieve. And when it comes to foreign arrangements, again, you there cover hundreds, thousands of arrangements, many of which are completely innocuous. It's very time consuming to report them. A couple of years later, they appear on a website, but without any sense at our end, what should we have changed? What should we be doing differently? And so both of those schemes, I think with the benefit of hindsight, just aren't delivering benefits compared to what is working.
Thank you. Mr Chesworth, I think had your hand up there, or?
Thank you, Chair. Broadly supporting comments.
Wellard, sorry, Mr Wellard.
Yeah, Chesworth Wellard. One of us should have worn something other than a white shirt and a tie. Again, broadly supportive of comments of colleagues. There is sometimes a tendency to focus on the research activities of universities, but of course issues of foreign influence and foreign interference are important to all the activities of all all 39 Australian universities as well. In relation to UFIT, backing in Professor Williams, I think it's been the sort of the salutary lesson in how universities have been able to turn their eyes to this issue. I myself come from the defence establishment and have come into this sector and have been really surprised and impressed at the partnership between universities and government. We've had a refresh to the UFIT guidelines. We've had a number of activities involving our Group of 8 colleagues, our ATN colleagues and other groups, such as hosting online forums where we've had the most senior officials from the intelligence establishment addressing us. And we've also had a range of forums and workshops as well where experiences can be shared. So I guess the thing I wanted to say is that, yes, we can look at the legislation, we can look at the regulation, but that legislation regulation doesn't actually say much about the face-to-face interactions and the relationships that are occurring between universities and those in the know in government. And I was just noticed also that last year, I understand that universities approached ATO around about 60 to 65 times. It's around about 60 to sort of seek advice on issues in this area. So we've got a bit of a runway. Yes, we're talking about FITS here, but you know, with UFIT, we've really got 4+ years of experience. We're not starting from scratch, and there is perhaps a discussion to be had about the place of FITS in the mosaic of regulation. It's a bit like whack-a-mole. If you hit something there, it's going to have an impact somewhere else in the regulatory framework. But yes, supportive of comments of colleagues, Chair.
Thank you. Thank you. I might go to committee colleagues, if they have a question, starting.
Yeah,
I can see a hand up, so I'll go to the Deputy Chair.
Chair, Mr. Shi wants the call.
My apologies.
Oh, thank you, Deputy Chair. I couldn't see you there, Mr. Shi.
Thank you, Chair. I just wanted to add that driving cultural change in our universities around these broad issues of strategic interest. The foreign UFIT obviously has been the exemplar, but the foreign arrangement scheme has actually enabled some of our universities with a growing research and global footprint to better understand their arrangements and interactions globally. So it's actually driving cultural change. But when it comes to FITS, we've mostly spent our time on legal advice to better understand where it applies, and it tends to not apply. And so in terms of driving the change piece that we'd like to see in our universities, where we've had that opportunity to refine guidelines, work closely with departments, which has been the case particularly, of course, with UFIT, but as well with the Foreign Relations Scheme, with DFAT, that's been led to a better outcome.
Thank you. Dr. Byron?
Just a quick additional point. Thank you, Chair. One of the risks that we perceive at QUT, I mean, I agree with everything my colleagues have said, so let's take that as read. In addition to that, one of the risks that we perceive from the national interest point of view of the proliferation of requirements being imposed on universities seemingly without visibility of each other. And I'm thinking about foreign arrangements and critical technologies piling on top of FITS. And seemingly unaware of UFIT. So we have this arrangement of a whole lot of different compliance regimes, often being operated by the same individuals inside universities that are become obsessed with ticking the boxes and ensuring that we're on the right side of the thin blue line, instead of the actually dealing with underlying risk. And in my view, this addition of all of these additional regimes without visibility of each other is increasing underlying actual risk. Yeah. We are going backwards by trying to do all these additional things. And if the committee doesn't mind me speaking very candidly, it was very apparent that universities were added to the Foreign Arrangements Bill at the last minute for reasons that had little to do with actual risk to the national interest. And that has resulted in an enormous amount of additional work that can be costed, as Professor Wesley has done, but it also increases the the distraction of the people who are meant to be the sentinels from looking outwards from the parapet. Instead, they're watching what comes through the gate, lifting up every tarpaulin of things that just are actually not a major risk. And so it seems to me that harmonisation, and this is my elegant segue to the Deputy Chair's question, that harmonisation through the medium of UFIT is the way for us to address this. UFIT's working really well. It can capture more stuff, and it already effectively does have visibility of those other arrangements. And I think that if we can work collectively, as Professor Wesley pointed out, that doing some of these reviews, even if they're not simultaneous, inside of each other and in a coherent way, working towards coherence through the medium of UFIT is going to be how the universities will themselves be able to comply more effectively to the requirements of government.
Thank you very much, Dr. Byron. That's great clarity there. Deputy Chair, did you have a further question?
Well, I haven't asked one yet, Chair, so yes, I do.
Oh, well, you did sort of make an intervention into my question, but I count as a question. So
I don't count that as a question, Chair. Can I go to Ms Thompson initially? We've been talking a lot about the regulatory burden that's been placed upon universities through the FITs. But on page 4 of your submissions, you talk about, and I'll quote you, most GO8 members have indicated that once the FITS Act was implemented, the level of burden has been relatively low. Top of the page. You do go on to say that one of your members did have a significant initial impost. But I'm just wondering how that submission reconciles with what we've heard in the group, your collective evidence today.
I think the issue there is, going back to my earlier comment about we've become a little more sophisticated, if you like, in terms of addressing these issues and putting in the processes. And so I think, as Professor Wesley alluded to, you can use the same process potentially to pick up, whether it's through the FAS or whether it's through Defence Trade Controls Act or whatever it might be. So I think I would defer definitely to our individual universities who have a greater oversight of the regulatory burden. And I think the point really also is that it's the level of burden in the context of everything else that we've got to do in relation to compliance. And at the outset, as Professor Williams said, we don't have an issue with compliance and regulatory regime, but if it's not clear what the purpose is, it makes it very challenging for us then to reconcile that, I guess. And I probably have a slightly different view to my colleague in relation to the foreign arrangement scheme. That has been a significant burden on universities and that is a very different proposition, the foreign arrangement scheme, to the FITS bill. The FITS legislation covers all of us, every sector of the economy. The Foreign Relations Act, I think
unfortunately it doesn't. I wish it did, but it doesn't. But anyway, I won't argue the point with you.
Sorry, I missed that interjection.
You said it covers all parts of the economy. It doesn't.
FITS, I'm talking about.
FITS, yes.
Well, it covers a broader range than perhaps the Foreign Relations Act.
Right.
So the Foreign Relations Act, we were literally thrown in, and we knew we were thrown in by reading the front page of The Australian. I mean, it was just, if you want a case study of how not to develop legislation and bring your constituency with you, that was it, to be honest. Right. But I know we're not here to talk about the Foreign Relations Bill, but we've sort of gone to the broader remit. So I guess the point in that submission, which was made some time ago, remembering this submission was made in 2021, things have shifted significantly, and I think that compliance burden has been increasing, as we've heard from Professor Wesley.
So you're saying, or you're suggesting, Ms Thompson, that the compliance burden has increased with time, as opposed to once the initial process, you get up to speed on how this is all working, and then it sort of just ticks along. You're actually saying that that's not what's happening. The burden is increasing with time. Is that what your evidence is?
Well, I'll defer to our universities who are at the coalface of actually dealing with this, but what I will say at the broader level is we are having to deal with a range of legislation which necessarily doesn't speak to each other.
Yeah.
And so we're having to put in place regimes within our universities when what is the core business of universities? It's teaching and it's research, but we're putting in place processes now, and we're establishing an industry, if you like, in terms of that compliance regime to deal with that. And I want to be very clear, we have no issue with dealing with compliance and regulation, but if the two aren't speaking to each other and we're at a loss as to what one is supposed to be doing and what one isn't capturing, I think that's where, and I think Mr Shee raised the issue of, seeking legal advice has been the main progress that they've done under FITS. That doesn't come without an additional cost to our universities.
I'm not meaning to single you out. It's just, Ms Thompson, it's just a number of things that you've said have sort of piqued my interest. And I think it was you in your earlier evidence said yourself that there seems to be a fairly common misconception between, or a conflation, I think was your word, between foreign influence and foreign interference. And I also gleaned from your earlier evidence that there's obviously an exasperation on the part of the university sector that you're going, and I think Professor Williams put this very well when he said, the FITS is high compliance, low impact. And so, the universities are basically saying, why are we going through all of this cost when there doesn't seem to be anything of any value coming out the other end? But doesn't that succinct summary actually conflate the two? Because the foreign influence, I think most of us would agree that we're not saying foreign influence is bad. Foreign influence and the Foreign Influence Transparency Scheme is designed to draw out into the public so that we can all see. Transparency is the best form of disinfectant, as we all know. It's the things that we can't see that then descends into foreign interference. So if something is being drawn out and it's sort of made public through this scheme, then it's kind of doing its job.
But I think the point is that this legislation isn't doing that job. Isn't that the point?
Well, that's
and so I wouldn't want to be mischaracterised to have a view that I've said there's nothing to see here, because that's not what I'm saying. We all are aware that foreign interference and foreign influence exists in many domains, in many sectors, including the university sector, and we wouldn't have established such a successful UFIT process if we didn't believe that and worked and co-created that with government over the last 4 years or so.
Yeah.
But I think, as Professor Williams has said, and I think others have said, the legislation in its current form is potentially, and I heard the evidence, previous evidence, is not actually picking up potentially what it could be picking up.
Yeah.
And so there's this inherent tension, and there always is, between, and this is the grey area I think that your chair has referred to, between foreign influence leading to foreign interference, and this grey area in between. But we're talking about the FITS bill, which is not necessarily picking up what maybe it should be. I don't know if it is or it isn't, because I'm not across what it's picking up, but you only need to look at what's on the register to see there's not much on the register.
Maybe I can add a bit that might help you with the compliance question, because yes, I did advisedly use high compliance, low impact, and the compliance is over a period of time. It was high at the beginning, particularly with legal advice. Now it's much lower. It has tailed off. But where there are compliance costs for FITS, it's typically needing legal advice to decipher the complexity of the legislation, only to find that it doesn't apply. That's usually how it works out. We haven't registered anything because we keep getting the advice consistently it's not covered by the legislation. But that can be an expensive process sometimes, getting that legal advice, and hence to our end, we just wonder what the point is.
Yeah. Thanks, Professor Williams.
Thanks. And could I just add very briefly, there is no kind of mechanism of then engagement with government to tell us whether government believes that we've been compliant or not. And this would be consistent with the Foreign Relations Act as well. Universities were told that we had to make judgments about whether a foreign entity was independent in terms of academic independence under the legislation, and we had to make our own judgments about which countries, in terms of their higher education legislation, were fostered academic freedom or not. Now, every university did that, I might say at great legal cost and a great deal of staff time, But at no stage has any part of government reached out to us and asked us where we made the judgment and whether they agree with the judgments we made. So we have no way of telling whether we have been actually compliant with the intent of the legislation. We believe we have. Very high-priced legal advice believes that we have, but no one from government has been in touch to tell us whether we have or not.
Mr Chesworth, you wanted to, you had your hand up?
Thank you, Chair. Mr Wallace, you commenced this line of questioning in relation to issues around regulatory burden. The simple point I'd like to make is that universities are not sort of cookie-cutter institutions. They range in size, activity, and the ability and the capacity to absorb regulatory burden as well. So to that extent, there will be some institutions that can manage this regulatory burden better than others. And so it's to make the simple point that we have a regulatory regime here that has grown very responsibly, very quickly, particularly since 2017, of which FITS is one part. And that inevitably means regulatory burden sort of grows in a cumulative way. And that's simply to make the point once again that if these issues are to be looked at, particularly around regulatory burden, universities stand ready to meet the regulation that we need to deal with because it's important for our reputations. But it's also important to do, I think, so like a fairly close, almost stock and flow analysis of regulatory burden to work out to see how each part is achieving its ends and how each part fits together. Thank you.
Thanks, Mr Chesworth. That's all I have, Chair. Thank you.
Thank you, Deputy Chair. Any other questions from colleagues? I know that Mr. Hill's there
it's
now.
Julian. I just wanted to ask a follow-up actually about that. The last.
Please.
Is that okay, Chair?
Go ahead, Mr.
Thanks.
Hill.
Just about that last set of exchanges around your interaction with the regulatory agencies, departments, depending on which scheme we're talking about. What words would you use? I think we're looking for adjectives. What words would you use to describe their current attitude or your current relationship with you? And what words might describe an ideal end state? I'm just trying to understand because I'm a bit surprised. I mean, my observation on this from the outside is universities are not trying to do the wrong thing. I don't think we should be suspecting you of being malevolent actors. But equally, there are serious risks, as everyone knows and acknowledges, that need to be dealt with. But I'm just trying to work out, like, have we got an adversarial? Have we got a hands-off relationship? Are you looking for a partnership? What sort of shift would you find lowers the regulatory burden and improves compliance outcomes?
I might just pick up that using the UFIT process.
I'm staring at the people at the table, Chair, but, you know, free-for-all's fine.
So I would not characterise it as adversarial. That's not an adjective I would use. And in fact, I would use, you know, and remembering I'm representing 8 universities, I'm not ringing agencies every day and talking to. So others who are doing that may have a different process or a different view. But I think what we've got is a very open communication process because of the University Foreign Interference Task Force, where you've got, you know, Home Affairs and ASIO and others sitting around the table with the universities. So at that macro level, I think that's very positive. And the way I've characterised it in the past is if we go back and look in hindsight, we basically had 2 different tribes coming together. One that is very open, which is us, and one that is used to sort of being quite sort of clandestine and secret and getting about their business. And you brought those 2 groups together. We should not forget the significance of that. So in that context, I think it's actually a very good process we've got. And what we are saying, at least what I'm hearing from my colleagues, and we're certainly saying, is let's use that process to look at what we've now got, which is a myriad of legislation and review of this particular legislation in particular. Let's use UFIT as a sounding board and a testing board to actually run things past and through them. And I will just call out the Department of Foreign Affairs and Trade as it relates to the Foreign Relations Bill Act. That certainly is a very positive relationship because, and this is my own observation, not on behalf of anyone, I think they too are trying to make a scheme which was fairly unwieldy work, and they have certainly reached out to us at the Group of Eight to say, how can we make this work in a more light touch way but an effective way for your university? So I would say from my perspective that's been very positive.
And can I just add from the University of New South Wales, it's the same, it's very warm, positive relationships, high reliance, it's working well. But I feel for them just as what we are describing because they are dealing with statutes that are legally incoherent. The reason I suspect we can't get answers from them is they can't work out the answers either. And as a lawyer myself, it's very difficult to give advice about terms that are so vague and difficult. And it's very clear to me that the departments will have exactly the same problem. And we're struggling in this sea of uncertainty with this legislation that on both sides is unsatisfactory.
And just
Thanks,
very quick.
Mr. Chesworth, and then I'm going to go to Mr. Wilson for one final question because we're running out of time. Mr.
Okay.
Chesworth, you had your hand up.
Thank you, Chair. I'll ask Dr. Wellard to make some comments.
Thanks, Peter. Look, in response to Mr. Hill's question, the relationship between UA and the various agencies involved has been very productive. It's been a little bit different depending on which agency you deal with. I would echo Ms Thompson's comments regarding the relationship between universities and DFAT. Even from the point when the draft legislation was originally introduced, they were very proactive in engaging with us as a peak body, but also our members in terms of providing us with information regarding the purpose of the legislation, taking feedback from us in terms of queries that we had. And that's been an ongoing relationship which has evolved in a very positive direction over the last couple of years to the point of where we now have them as regular attendees to our various policy discussions. We receive updates in terms of what's happening on the public register, and they're also very happy to take feedback in terms of some of the public information they provide. And I would use the way in which DFAT has gone about working with the sector as a good example perhaps for the way in which the AD, the Attorney General's Department might think in terms of engaging in relation to FITs. They've been outward facing, as I said, very proactive, and they've been great in terms of providing information and case studies that we have been able to use. And so it's been a good experience.
Thank you so much, Mr. Wellard. I got that right.
So I think Professor Wesley was trying to say something. Sorry, just.
Oh, thank you, Mr. Hill. Professor Wesley.
Yeah, look, at the risk of slightly disagreeing with my colleagues, I think that there are certain mechanisms that have worked well, but there are other areas where I think we could benefit from much greater involvement, particularly around, as I've said, the review of how universities have interpreted various unclear bits of legislation. My sense is that certain parts of government are less forthcoming than they could be, particularly about the specific nature of threats that the university faces. I note the PJCIS report on foreign interference in universities suggests that ASIO provides a clear annual assessment of foreign interference threats that universities face. I think certain agencies of government are very reluctant to provide more detailed advice, which quite frankly would help us in addressing the enduring foreign interference risks that we face rather than having to comply with unclear bits of legislation. So I would urge more openness from certain parts of government and more regular interaction from certain parts of government.
Just very quickly, Chair, through you, isn't that done through UFIT?
I would argue that UFIT is quite a narrow body and what we need, because this is something that universities are dealing with every day, is more engagement at the university level.
Thank you, Professor Wesley. Unfortunately, we've run out of time, but I do want to thank all of you for your attendance today. If you've been asked to provide any additional information of answers to questions on notice, the Secretariat will be in touch regarding timeframes for providing that to the committee, and you will be sent a copy of the transcript of your evidence once it is available in the coming week, and you'll have an opportunity to request corrections to transcription errors. Thank you very much, all of you, for your attendance today. Much appreciated. Colleagues, can I ask committee members just to stay back for a second, because we do have to move a resolution as two opening statements that were presented by Ms Vicky Thompson, G08, and Luke Shee, ATN. They provided opening statements that they did not read in full, and we just need to, if I could ask a member to move that the documents presented by Ms Thompson and Mr Shee be accepted as submissions, numbered, I think the Secretary will provide those numbers.
So moved, Chair.
Submissions to the inquiry.
So moved.
To the inquiry, authorised for publication. Thank you, Deputy Chair. Colleagues, I just do also have to suspend proceedings for lunch. Due to the continued disruption of proceedings, the hearing will now be suspended. Well, there's been no disruptions. It was quite a good session, by the way. Now be suspended.
What did I miss?
I don't know. I think the disruption is when you arrived, Julian. And I've got a little note here, colleagues, and some of you might see what the Chair knows. The Chair will lead the members of the committee from the room to previously agreed safe proceedings after the lunch break, and now welcome Mr Malcolm Turnbull to give evidence at this public hearing today. I guess for the Hansard record, Mr Turnbull, would you please state your full name and the capacity in which you appear before the committee?
Thank you very much, Mr Chairman. My name is Malcolm Bligh Turnbull, and I'm appearing before the committee in my personal capacity, having an interest in these laws, having introduced them myself when I was Prime Minister of Australia.
Thank you, Mr Turnbull. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement, if you have one, before we proceed to a broader discussion.
Yes, thank you very much. Look, I'll try to be brief, although politicians and even former politicians invariably disappoint when they say they'll be brief. Look, firstly, these are very important laws. When they were introduced at the end of 2017 and when they were passed by the Parliament in 2018, they were really world leading. Australia should be very proud of being very much on the front foot in the face of foreign interference and in terms of demanding transparency of foreign influence. So I'm not here, as some media reports have suggested, to criticise these laws. I think they're very good laws. But as you know, they were new laws. We were ploughing new fields. And so when we drafted the laws, we provided that there would be a review 3 years after they'd been in force. And obviously with the vagaries of pandemics and elections, the 3-yearly review, which started in 2021, is still going. And that's what you're in the process of wrapping up. It's really important in areas like this to take a dynamic approach. Some of your committee members will recall me saying when I was in office that in areas of national security, there is no place for set and forget. The environment is constantly changing, and you've got to be prepared to adjust and adapt and learn from experience and, redo your position and indeed your legislation. So what you're embarked upon is very important work, and it's work that was anticipated when the legislation was passed. Now, I would say this, that the object of the FITS legislation, which you're reviewing, was always transparency. We were not seeking to stigmatise or demonise people who were representing or acting on behalf of foreign countries or indeed foreign governments or indeed foreign political parties. It was all about transparency. Sunlight is a great antidote to activity which may otherwise develop into covert and even coercive activity. Now, there is an issue, and I know that Daniel Ward, a very fine lawyer, has written about this for ASPI. There is an argument about whether the legislation should be country agnostic, which it is. There are powerful arguments for the status quo of country agnosticism and being more specific, as the British, as I'm sure you're aware, are planning to be in their draft legislation, which seeks to sort of emulate what we've done. There are challenges with being specific, because you will find there are things change, and there are countries that we may have friendly relationships with, but whose activities in Australia we'd nonetheless like there to be transparency about. So, you know, it's a finely balanced test. However, I think a key part of that is to make the legislation easy to comply with. I've raised this with the department in the past. Their online interface was very clunky and not very intuitive. If you are going to compel people to report something to the government online, you have to make it really easy to comply. It's got to be as easy as buying a book on Amazon. It's got to be that simple. And of course, if you make it simple, then the regulatory burden is much less, and the issue then issues about country agnosticism become less material, because the burden of complying with respect to relations or associations with countries and for which there are absolutely no concerns are not very burdensome. I would say, based on my limited engagement with the legislation since I left office and my observations, it would seem to me that the problems that have arisen are not so much in the legislation, although that no doubt could be improved and fine-tuned in the manner I've described, but in the manner in which it has been administered. You know, legislation like this has to be administered in an intelligent and risk-based way. It shouldn't be approached like a sort of robotic box-ticking exercise. It's got to be administered with a view to where the real risks and concerns are, and it's got to be administered in a proactive way. I mean, it is noteworthy that there is apparently, according to the Transparency Register, there is apparently no organisation in Australia that has any association with the United Front Work Department of the Communist Party of China. Now, I would love to think that was true, but regrettably, I can say absolutely that it is not true. And in fact, it would be, if in fact it were true, there would be terrible repercussions in Beijing for those responsible for the United Front Work Department. So, you know, I rather wonder why time would be spent seeking, you know, Kevin Rudd to record his interviews with the BBC, which is, after all, a state-owned broadcaster, and perhaps time might be better spent actually finding out why a whole range of organisations are not reporting associations that are widely known to occur. So, you know, if the upshot of the register is that it simply records relationships, associations with foreign governments and foreign political parties, and I mean, really, that's a small subset and is, you know, obviously largely focused on countries which are effectively party states, like China. If the register simply contains, you know, reports of associations that are innocuous, and many of which are already in the public domain, then it may be that, you know, officials can congratulate themselves of faithfully implementing the law, but they're essentially doing a work to rule and not fulfilling the object of the legislation. So, you know, in conclusion, and I really came here to be of assistance, and, you know, happy to answer any questions or discuss, and look forward to discussing these matters with you. You know, we need to ensure that not simply that the laws are right, but that they are being administered and enforced in a practical, risk-based, proactive manner. Those are my opening remarks, Mr. Chairman.
Thank you very much, Mr. Turnbull. Look, speaking for myself, I've been in 20 plus years in national security and defence roles, representing here and representing Australia overseas. And I've done plenty of speeches and media interviews, probably not as many as you, Mr. Turnbull. But we note with some interest that you alluded to some of these activities that you've had to register yourself on the FITS. I mean, would be concerned about this. So you were a foreign agent, and surely the intent of this bill when it was first put to the Parliament was not to capture this type of activity of former Prime Ministers or former Cabinet Ministers.
No, well, it certainly wasn't. I mean, that was absolutely, I certainly did not have that in my mind. I'm not making any complaint about that, by the way. I mean, I gave a speech to a forum in South Korea, and another speech to a forum in Taiwan, each of which had governmental associations, but they were public events and the speeches were broadcast. So there was nothing, covert or about it. But no, I've got no problems registering that. I think you've got to make it easy to register. But it absolutely was not what we had in mind. I mean, we clearly, we had in mind, you've only got to look at what I said in my second reading speech, that we were concerned about foreign governments and foreign political parties seeking to influence Australian public affairs. And it was, again, and we're not saying we weren't saying they shouldn't do it. We're just saying it's got to be public and open, transparency is the key. But of course, if you're writing letters to former prime ministers about why they haven't registered a speech which the department has learnt about because it was widely reported in the press, it rather does make you think that the object of the bureaucrats' concern was not transparency, but box ticking, because the transparency was there. The speech was published. It was on, the host's website, my website, and reported in the news.
In your opening remarks, you talked a bit about the issue being more around the implementation of the scheme and the administration of the scheme, although we have heard quite a bit of evidence and through submissions that questions around the narrowing of the definitions around what is a foreign principal and those definitions themselves are problematic because they basically narrow the ability of those implementing the regime or administrating it from actually broadening the scope.
Could you unpack that for me, Chairman? Just to expand that a little bit.
So the issue around the definitions of what a foreign government-related entity is and a foreign-related individual have been narrowed to the point that there's a very high threshold with respect to there having to be a substantial or almost total control over that entity with respect to the activity, rather than things like partial control or funding of activity not meeting that threshold. So there's a question mark around the definition.
Well, that could be useful. If you think that's the case, your committee thinks that's the case, you should recommend some amendments.
Yeah, and I was going to sort of get your insight on this, or seek your insight in the sense that where you think the reforms or improvements could be made to the Act. I know we've heard some evidence has said that times have changed. Obviously, some adversaries and state actors have become more aggressive and more disruptive and sought to interfere in more ways over the past 4 years. But do you think, from your perspective, that there are elements of the Act that can be reformed, amended to improve both the definitional part of it and the scope of capturing the right type of activity, not you doing a speech or Mr. Rudd doing a BBC interview?
Well, look, let me cut to the chase. I rather suspect what you're talking about is the Chinese telecom company Huawei, which of course is not a state-owned enterprise, and it may be that people have said, well, Huawei is not controlled by the government, it's not an SOE, and it's not controlled by a foreign political party, i.e. the Communist Party, which for all intents and purposes is the government of China. So they're sort of essentially the same thing. I think the answer there is that I would. I did turn my mind to this when the legislation was written, and my view was that companies of that kind, which were in a position where they had to comply with the directions of their government and a particular political party, would be caught. But if the lawyers feel that's not the case, then you amend it. I mean, that's that again. This is exactly what this committee is meant to be doing. But if you have a company which claims to be and perhaps is arguably non-government owned, but nonetheless is obliged to, or has habitually complied with the directions of a government, then it should be then the net should include it plainly. I mean, you've just got to be practical about this.
So, thank you for that. I want to make sure that I get your opening remarks in context and correct. You obviously still think that the scheme is very important. It's salvageable. There's reform that can be made to it, amendments that can be made to improve the scheme. So you don't think the Fitz is on the complete fritz, as it were. You think it's a very important set of laws.
I don't. Well, I mean, you've had evidence this morning from I think Catherine Manstead saying how important the scheme is, and it is vitally important. Yeah. Transparency is important. It's just a question of making sure that it works. It works well and it's administered well.
Yeah. So one area of reform that you did touch on was this question around country agnosticism or being country specific. We've also heard evidence from Ms. Manstead around not so much prescribing country specific amendments, but really having the guidance within the framework, within the regulatory framework, that those administering the scheme can better judge the influencing activities of an authoritarian state versus a democratic state. Could you give us your thoughts on that?
Well, plainly, the states which we're concerned about are almost without exception authoritarian states. So, there's probably some few exceptions to that, but it is overwhelmingly authoritarian states, and that's why you've got to have a risk-based approach. And it does. Look, if the people administering it are doing so grudgingly and on the basis that they're going to do no more than comply with the letter of the law, then it's not going to work. I mean, frankly, no legislation works on that basis. You've got to understand both the statutory language and the intent of the legislation and make sure that you implement both. And if the statutory language is inadequate to achieve the objects of the legislation, then amend it.
Before I turn to colleagues for the next question, just the last question, do you, given that you introduced this as Prime Minister, as you pointed out, do you feel disappointed that the Fitz hasn't actually achieved what you intended it to achieve? Do you think this is more to do with the fact that some of the state activities and influencing activities and interference has actually increased over the last 4 years? Or is there an element of, regret that you could have actually tightened some of the definitions, made the scope more broad to cover those types of activities?
Well, we actually narrowed the scope. I mean, initially the scope of the legislation in the bill that went into the House was very, very broad and would have picked up pretty much any foreign entity or company whatsoever. It was too broad, in fact. So we did.
Do you think you narrowed it too much?
No, I don't think. Well, look, I don't think so. What are we concerned about? We are concerned about foreign governments, foreign political parties. That's basically what we're concerned about. We are not concerned whether somebody is representing a public listed company in the United Kingdom or France or something. Whether they are, if they're a lobbyist, obviously they've got to register on something else. I think the problem is not the legislation. I mean, the United Front Work Department is an agency of the Chinese Communist Party. It is acknowledged. It's not a secret organisation. It is, Xi Jinping has described it as the magic weapon. Very well documented, and yet apparently nobody is declaring any connection with it. in Australia. Now, that beggars belief. That's got the is clearly caught by the legislation. So that is an enforcement problem. But having said that, I'm sure you can improve the legislation. So I'm puzzled that the legislation has not been more rigorously enforced. There may be some reasons for that, but I'm proud of the fact that we introduced the legislation when we did. And, you know, it often takes time to get this type of thing right. It is, I say, it was new legislation.
So in your view, you wouldn't recommend moving towards a more country-specific approach? You'd recommend more enforcement?
Yes, I think, look, I've thought a lot about that, and if you were to recommend a specific country-specific approach, I would understand why you did it. But I think on balance, and I have very high regard for those that have expressed these views, I think on balance, I would stick to the situation, the rules we have, make it much easier to comply with, focus on the authoritarian countries that are really the matters of concern. You could perhaps consider rather than having a list of countries of concern, which is what I think the British are looking at, you could, on the other, I would recommend you consider having a list of countries about which we are not concerned, if you like. You know, for a start, you'd start off with the Five Eyes. I mean, we are really not troubled by, you know, our closest people representing or working with or associated with our closest allies. I mean, it gets back to Kevin's BBC example. But, you know, the object is to make it easy to comply with, but make sure that the key object is pursued and enforced. But again, if you were to recommend to go to a country-specific approach, I would understand that, but you will end up with some grey areas. You know, I mean, it's obvious you would list. You know, you would list People's Republic of China, Russia, Iran, North Korea. That'd be the top four. That's easy. Then, of course, who else is in there? And that's where it can get a bit contentious. Yeah.
Thanks, Mr. Turnbull. I saw Mr. Hasty put his hand up. Mr. Hasty, you had a question?
Yes, good afternoon, Mr. Turnbull. Good to be with you. I was just going through your second reading speech, and I've got to say it looks remarkably fresh, given it was given in December of 2017. And in fact, if you come to the sub-paragraph, protecting our democracy, you could almost stand up in Parliament the same speech today with a few tweaks, and it would stand up. So I think my point here is that the objectives of the legislation were quite clear back then, and they're still clear now. And I don't think the geopolitical situation has changed very much. Indeed, it's evolved.
It's got worse, really.
Sorry?
It's got worse. I mean,
it's got worse.
Concerns we had in 2017 are more exacerbated today. Yeah.
Sure. I actually call this the China pivot speech, because there's a paragraph there where you say, today and every day, the Australian people stand up and assert their sovereignty in our nation with our parliament and our laws, which is true then, and it's true now. I recall, because I was chairman at the time, working very closely with yourself, Mr. Porter, who was then the Attorney General, and also the Shadow Attorney General, Mr. Dreyfus, over 6 months doing painstaking work on the legislation and the recommendations that we came to fix it. So I think back then it was clear what the objective of the legislation was. We worked on a bipartisan basis behind closed doors. And I think for a department receiving these laws subsequently, I don't think they could argue in hindsight that things weren't clear, nor were there countries identified that they should pay close attention to. I guess, is there anything that you would change about this speech to make it clearer for the department?
No, I don't think so. I think it's I wouldn't. I mean, you'd give a slight. The issues that we identified in 2017 were, in some people's minds, contentious. I don't think they are contentious in many people's minds today. And you know, I just say, I think, you know, I thought this committee, the PJCIS, did great work. You know, credit to you and to your Deputy Chair, Anthony Byrne, in back in 2018 really was when the work got done, and it was very collaborative, and I think we improved the legislation. But you know, it's got to be. This is, you know, our adversaries are not sitting there having a strategy and just leaving it untouched for years. They're adjusting their vectors of engagement and disruption and so forth. And so we've got to be as agile. It's, you know, it's like cybersecurity. You know, you can think you've got it sorted out, and then the people on the other side are just as smart, if not smarter than you, and they come up with something else.
Well, I'll hand over to other colleagues, but would you agree, or do you think it's unfair to say that there's been an institutional failure to carry out the intent of the laws as you described them in the second reading speech back in 2017?
Well, I mean, I'd like to know why it is that there are no entities or individuals reporting an association with the United Front Work Department. I mean, it is, and you know, the intelligence agencies have got a very good, security agents got a very good idea of who's doing what, and it is not, it's, you know, it's not, I wouldn't even describe it as covert. You know, it's pretty blatant operations, and I don't know what the explanation is, Mr. Hastie. I assume you've asked the relevant bureaucrats to give them. I mean, it does remind me of that, you know, scene in in Casablanca when the French police captain runs into Rick's bar and says, "I'm shocked to see that there is gambling in this establishment." And you know, I mean, what is this some sort of pretense that's going on? I mean, we know what's happening, and we just want it to be. We just want people to be open about it. That's all.
Sorry, just a supplementary, Mr. Hastie, to your question there. It's an interesting point you make, Mr. Turnbull. Would you therefore support a reform in which the presumption leads to the power to actually register that entity because that avoids the obvious flaw in self-reporting, not actually getting it done?
I think you've obviously got the power under the legislation to essentially issue a please explain, and you've got the authority under the legislation to investigate and inquire. So, but I don't look. I mean, changing the legislation in some respects is the easiest thing to do. But unless people are prepared to implement it and enforce it and do so proactively and, you know, intelligently, then, you know, there's just a bunch of words, really.
Sorry, Mr. Hastie. I apologise.
No, that's okay. I'd agree, Mr. Turnbull. I'd say it's my own conclusion is that there's been a lack of mission focus. There's been clear political objectives. There's been an act established, and there's been a lack of mission focus at the departmental level. That's all I have. I will close by saying I was recently sent the Casablanca clip, but in relation to the spy balloon. So it's going around.
Yes, that's right. Yes. It's a well-worn meme in the field of intelligence. That's for sure.
It is.
Senator Smith, Mr. Wilson, or Mr. Hill, do you have any questions? Or Senator Ciccone?
Peter, it's Julian.
Mr. Hill?
Yeah. Look, thanks, Mr. Turnbull. I've been listening carefully. I think you've mounted a clear and robust defence and reminder of the purpose of the legislation, which everyone signed up to, and thank you for that. I'm just struggling to discern or distill any specific recommendations beyond do better, enforce it. And I just invite you perhaps, and maybe that's the point of the outing here today, which will no doubt get attention on the fundamental point you're making.
Yeah. penetrating glimpse of the obvious, perhaps, but it's nonetheless one that seems to have been overlooked in some quarters.
Yeah, so a good stirring reminder of the importance of the task which we're engaged in here. Not a lot that's specific, perhaps, that I could take or the committee could take in terms of recommendations, but I'll just remind you, of course, if anything occurs to you as you hear, because you're obviously personally engaged in the issue with the rest of the evidence, we'd welcome any further specific suggestions for improvement, as well as some good penetrating questions to us, the bureaucrats, when we get there, no doubt.
Yeah, good.
We've got that. Thank you.
Thank you, Mr Hill. Senator Birmingham or Senator Patterson?
Yes, thanks, Chair. Sorry.
I'll go to Senator Birmingham.
James.
Sorry.
Okay, thank you.
Going by.
Mr Temple, thank you very much for joining us today. You are perfectly well suited to speak to the intent and the objectives of the legislation as the Prime Minister who introduced it. You've talked a lot about the United Front Work Department. That was one of the specific targets of this scheme, wasn't it?
Oh, yes, absolutely.
And do you think there would be any doubt in the minds of the Attorney General's Department employees that that was the case?
None.
How then can you account for their failure to investigate them adequately and get them to register on the scheme?
I can't.
Yeah, we can't either. I'm utterly perplexed by it. As you said, nothing has changed since you were Prime Minister, and that was the priority. It remains one of the top priorities today, and yet they don't appear anywhere on the register. You've talked a lot about the tension between better enforcement on the one hand and changing the legislation on the other. As a parliamentary committee, obviously, we're constrained in this respect. The only thing we have an opportunity to express a view meaningfully on it is the legislation itself. We can express concern about failure to enforce it, but ultimately none of us are the responsible minister. If it is the case that the Attorney General's Department is just bewildered by the objectives of the scheme and cannot implement it as asked, what option is there to us other than to recommend legislative change to force them to do so?
Well, you could recommend if there's some sort of institutional problem in the Attorney General's Department, and I struggle to see why that would be so, but if there is, I suppose you could recommend it be moved to Home Affairs, but I'm not sure, that's all I could think of on that score. In terms of changing the legislation to get people to do what the legislation already tells them to do, it's, you can see you're just chasing your tail.
Yeah.
So the real question should be to the officials is, why is this area of transparency relating to Chinese Communist Party organisations and associations not being disclosed? And if they say, well, it's because the law has this defect in it, well, it may be. If you're convinced of that, you could recommend to change the law. But given that the whole purpose of the legislation was to achieve this, that was not the sole purpose, but I mean, it was a key purpose. It does seem odd that it hasn't been pursued. So, there was anyway, there is certainly in the national security community, which I still have some, associations with, I would think and I think some of you would agree with this, that there has been a general perplexedness or, perplexity, I'm not quite sure what the noun is, a state of being perplexed about the failure to pursue it.
Mm. There are some exemptions under the Act which might be causing some challenges. You've talked about what constitutes a genuinely private enterprise in a country like China, so we'll park that. But also lawyers are exempt in some respects, not in their totality, but exempt if they're representing a company in a legal proceeding, and charities are also exempt. Do you recall what the reason was for those exemptions, and do you think they merit remaining in the legislation?
I'm not certainly with lawyers representing clients. That's if they're representing clients, particularly in litigation. That's a matter of public record. There may have been some issues of legal professional privilege, but as with charities, there were some concerns. The Catholic Church expressed some issues about the association with the Vatican as to whether they were representing the state of of the Vatican. But I'd have to, I think I'd have to be hard for me to recall precisely those issues there. But look, the bottom line is these are all ephemeral, fringe issues. The real issue is that the most active state and political party seeking to influence public affairs in Australia is that of China and the Communist Party of China. We know that. But they don't seem to appear on the register. Now, but a lot of other countries do. And, there may even be some other political parties, I don't know. But so there does seem to be a lack of enthusiasm. And I think, as I said, and again, I'm not making any complaint, but spending bureaucratic time reading the newspapers, noticing that a former Prime Minister gave an interview to, the BBC or gave a speech in, South Korea, and then writing them a letter to say you should put this on the register. Again, I've got no complaints about that, but you do think that the time spent on that could be more usefully disposed of, focusing on what the legislation was all about in the first place.
Well, that does seem to indicate that there's some merit in the idea advanced by Daniel Ward and others that this country-agnostic approach should go. I mean, I accept the arguments you made against it as reservations. I think they're reasonable points.
Yeah, they're more reservations. I'm not against it. I'm just saying that you will get some countries that are on the margin. I mean, there are countries that and it changes. So you might be better off just starting off by excluding countries that we have direct alliances with that we're not. Anyway, let's not. This is something you've got to weigh up in the weight of all the evidence. I wouldn't be surprised if you took Daniel Ward's advice. Equally, you could solve the problem by sticking to country agnosticism, but enforcing it in a more intelligent, risk-based manner, assessing risk realistically, and at the same time making compliance simple.
Okay. Thank you, Chair. Thank you, Mr. Turnbull.
Thank you.
You're on mute, Chair.
Thank you, Senator Patterson. Before I go to Mr. Wilson, just a supplementary question for you, Mr. Turnbull. We've spent quite a bit of time talking about the lack of enforcement or the need to strengthen enforcement mechanisms. I just, given you were there at the time in introducing the bill and the Act and overseeing that as Prime Minister, the original bill, and we talked about the narrowing of definitions and why you did that, the original bill had much broader definitions around what a foreign principal actually is. It included, for example, foreign businesses and public enterprises. And I know in your earlier evidence, you pointed out that this was, you didn't want this to be so broad that it covered all these companies in the UK and the US. But given that the original bill was more aligned, more similar to the FARA, the US legislation, and also now the FERS, which is coming through the UK, I just want to go back to that question of definition. If we looked at this issue of broadening the definition of what a foreign principal is to include some of these other entities, would that also assist in the improved enforcement of the transparency scheme, in your view?
It would. I think it would be more likely to actually make it harder, because you'd have a greater universe of entities in respect of which there had to be reporting. I mean, you've got to recognise that every time Parliament passes a law that imposes regulations and compliance on people, that's a cost to business. That's, it's distracting them, business people and citizens, from more useful applications of their time, and it does the same thing in the public service. So I think you've got to focus on, the key thing is to focus on what is the main objective, and make sure that is targeted. That's it. It's pretty simple, Chairman. I think that we know what the legislation was designed to do. I said so in the second reading speech that Mr. Hastie was so generous about. But if you cast the net so wide, that it includes, in addition to the things you want to catch, thousands of other associations, you run the risk of losing them.
But by your own admission, you've obviously pointed out a couple of times how the net is so wide now that it's capturing interviews on the BBC or speeches that you might make that are already in the public domain. You know, we've heard evidence about the weighting around enforcement to take into consideration the way that authoritarian states do their influencing, and that could be guidelines or a guidance for those administering the regime. I'm again wondering why. Well, what I guess the reason. Give us the reason why you chose to narrow the definition from the original bill to the Act when it was finally passed.
The way the original bill was drafted, on reflection, and I mean, and this was after discussions with the committee, which Mr Hastie was chairing and Anthony Byrne was deputy chair of at the time, it was obvious that this was going to include an enormous universe of associations, most of which were completely innocuous and of, you know, frankly, of not much interest, and many of which would be in the public domain anyway. You know, the objective was to narrow it to make it more effective. But look, if there's some, you know, if attorney generals come to you and say, we would be pursuing these targets that you're concerned about if only this section were amended in such and such a way, then, you know, you give that very serious consideration.
Well, I appreciate your pragmatism, Mr Turnbull. Thank you. Mr Wilson, sorry to butt in there.
Thanks, Chair, and thank you, Mr Turnbull. I mean, the scheme created like a sieve or a screen, and you lifted it up out of the beach and you got to see certain things that you wanted to see, and it had a general kind of transparency benefit of that kind. But everyone we've heard from says there were these obvious things that we always had in mind, these United Front associations as one example, that we expected to be picked up in that screen. And yet they're still lying there on the surface of the beach. They're still obvious to everybody. We didn't really need the screen to tell us about them, but we certainly thought they'd be picked up in the screen, and that hasn't been the case. The way the scheme has worked seems to have been pretty consistent over previous years, about catching about 200 separate activities, about 100 or so foreign principals. And then there's this sort of mechanism for perhaps going out and correcting the flaws in the screening system by issuing information gathering notices to people who should be liable to be registered and so on. That doesn't seem, even the most recent annual report suggests that that's happening only a handful of times each and every year. I guess that the thing I'm interested in is in the years particular, I guess 2020 and 2021, after the election in 2019, none of the things that you expected the scheme and the legislation to properly cover were being picked up. Was that something that was that an observation or a question that you ever had the opportunity to make to the Attorney Generals at the time, to Attorney General Porter or Attorney General Cash?
No, I didn't. I don't recall discussing it with either of them. But you know, obviously this committee provides an opportunity. But I think you summed it up very well there, Mr Wilson. The problem is that the please explain letters, if using a non-technical term, are not being pursued. You know, the powers are there to chase this information up, but it's not being undertaken. So you know, your description really underlines that the problem is largely one of enforcement and administration.
And the reality is that by the time that was operational, you departed the scene. So you had no.
Yeah, no. Well, I was gone by, you know, August 2018, and the laws had only just been gazetted. So if that.
And so there was nothing that you observed or
not while I was in office,
part of informally at the time, that made you try to reconcile the difference between what you would have expected and what seemed to be occurring.
No, the administration of the scheme came after my time in the House of Representatives and my time as Prime Minister.
Yeah. Thank you, Chair.
Thank you, Mr Wilson. Senator Birmingham, I think you've been very patient.
Thank you, Chair. Always very patient. Mr. Turnbull. I'm not sure I've called you that for a long time. Hello.
Yes, well, hello, you
today.
Yes, Senator Birmingham. So good to see you again.
Indeed. Can I jump through just a few things? We just touched on, and you referenced there the opportunity under the current system for the letters to be sent, requiring, in a sense, a response as to why an entity shouldn't list. There is the proposal to, in essence, reverse the onus of proof in that regard, that indeed the government, the relevant administering authority, could be tasked with the right to, in fact, register, to list, and that then of course, an entity would have to establish why they should be removed from that. Do you think that could be of benefit? And in undertaking that, do you think that could help to put some greater grunt into those administering it in terms of how they might pursue the scheme?
Look, it could. I mean, I'm never. There are problems with reverse onuses, of course, but it may be that that's a practical solution. So I think that the critical thing that I, respectfully suggest to this committee that you want to achieve is that if you think the objects of the legislation are valid ones, and it appears you do, then to ask the question, why are they not being fully realised? And then consider what your options are for ensuring that they are fully realised. And that's clearly one of them. But I think an enthusiastic enforcement and administration would go a long way too.
The National Security College paper, Domestic Security Grey Zone, makes a few recommendations that touch on areas for consideration here. One of them goes to the question of country agnostic approach. There's been the talk about a blacklist. You posited before maybe there could be a whitelist. This paper suggests that perhaps greater focus on being, they describe it as context aware, or attributes of concern perhaps about how a country's foreign policy and strategic objectives could influence Australia and how that country uses them in their system. Do you think there may be a pathway through the maintaining country agnosticism, but truly focusing the administrators on areas of concern by better prescribing what those attributes of concern from countries could be, or that making them more context aware in their administration of the scheme?
Yes, I think the answer to that is yes, although quite why you need to explain in words of one syllable what the security context is to senior public servants is beyond me. But if that's required, then you could do that. You could have a straightforward. You could have a PowerPoint perhaps to make it clear.
All of us have had the honour of administering from time to time. Have wondered why things have to be explained like that occasionally.
Exactly.
The last question, Chair, again taking from the National Security College paper, is their proposal to create some type of independent oversight. They call it an Australian Sovereignty Commissioner. I'm not sure I'm a big fan of the name, but they propose that there could be a means of bringing, with some independence, oversight of foreign interference as well as foreign influence type regimes into an entity with greater prominence, also greater focus than being administered in a Department of State would have. Is that something you've had a chance to have a look at or consider, given the breadth of concerns expressed about how the scheme is administered to date, or perhaps not administered?
Senator, I haven't had the opportunity to reflect on that in any sort of detailed way or lengthy way, but I would say, this is the job of the PJCIS. This is the job of your committee. So, I'm all in favour of taking these things very seriously. But if you've got one bureaucratic problem, is the solution to create another bureaucracy? Maybe the PJCIS could say that this issue should be brought before it literally every year. I mean, you'll remember years ago, we recommended that the Economics Committee bring all the banks before them every year, and that was a very salutary exercise. So all the chief executives of the banks know that every year they've got to turn up, and all of these unruly parliamentarians will ask them questions and be very blunt and forthright about it, and that I think that was a very useful thing to do. And it may be that you want to regularise your oversight about this. I know the committee's got a very heavy workload.
Thanks, Mr. Turnbull, for
putting a greater level of
workload.
transparency and accountability over the transparency.
That's right.
We do have a very intense workload. I appreciate the time is up, but the Deputy Chair does have one final quick question.
Okay, sure.
If that's okay with you, Mr. Turnbull.
Yep.
Good afternoon, Mr. Turnbull. Long time no speak.
Yes. Who is speaking to me?
Mr. Wallace.
Andrew Wallace.
Sorry. Sorry, it was hard to see you on the screen here. Yeah.
You spoke earlier, and Senator Birmingham talked about a white list.
Yes.
Now, you're probably best placed to comment on the diplomatic issues of creating a white list and how that would go down if you're not on the white list, where someone's clearly not a significant threat, but for reasons which some sectors of government may have some concerns about them being on the list. But how is that going to go down from a diplomatic perspective?
Well, it could be awkward, Mr. Wallace, and that is precisely why the legislation is country agnostic. It is because whether you have a white list or a black list, if you like, you're going to have exactly those problems. I mean, you could easily put the Five Eyes on it. I think everyone understands that the Five Eyes relationship is a very, very special one. There are lots of other countries that would like to become the sixth or the seventh eye, and I always take in the view that the Five Eyes has got a sort of certain historical status, and let's just leave it there. And when people say, why is it those five and not someone else, you say, oh, it all began, when 50, 60 years ago, and we can't remember quite why, but that's where it is. So I agree with you. Your concerns are valid, and that's why I'm not here saying to you we should adopt a country agnostic approach. I think it's something you've got to consider. That's your job. But intelligent enforcement, context-based, risk-based enforcement will make a big difference, and also making it really easy to report. I mean, as you know, I'm not sort of a digital dunce, at least I don't think I am, but I probably am as I'm getting older. But I'm not unfamiliar with the internet and so forth, and I struggled to work out how to report when I first did the report. It was absolutely not intuitive. And as I said, if the government wants to make it compulsory for people to do something, they've got to make it really easy to do.
I find it very hard to believe that a federal government website would be clunky, Mr. Turnbull.
Yeah, well, it was. And look, I could tell you, I asked them of an official, whether the Digital Transformation Agency or whatever it's called nowadays had been involved, and they said, "Oh no, we just developed it ourselves." I mean, it was pretty unedifying. I thought, this is all of these government websites should be the goal of the DTA, and the goal of government should be to make them as easy to interact with, as I said, as a big e-commerce site. They should be as easy to use as Amazon or eBay or something like that.
Usable and used. Thank you, Mr. Turnbull. I was
Thank you very much.
thinking that you were going to suggest we keep the white list with invisible ink only to be seen with the application of lemon juice by the Prime Minister or something like that, given your lemon juice diet. But anyway, thank you so much for your...
Thank you very much. Good to see you all, and I wish you well in your deliberations. Bye-bye.
Thank you. Well, I've got to read this out to you, Mr. Turnbull. Thank you for your attendance today. If you've been asked to provide any additional information of answers to questions on notice, the Secretariat will be in touch regarding timeframes for providing that to the committee, and you will be sent a copy of the transcript of your evidence once it's available in the coming week, and you'll have an opportunity to request corrections to transcription errors. Once again, thank you so much for your time and your insights.
Thank you. Thank you. Thanks a lot. Bye-bye.
Cheers.
Thank you.
Colleagues, we do have our next guest, and we're just 5 minutes behind, so we might get straight into that with that witness. I now welcome Mr. Alex Josk to give evidence at this public hearing today. Mr. Josk, for the Hansard record, could you please state your full name and the capacity in which you appear before the committee?
Thank you, Mr. Khalil. My full name is Alexander Josky. I'm appearing in a private capacity.
Thank you, Mr. Josky. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to a more broader discussion. If you do have one, please go ahead.
Yeah, thank you. I'll probably keep it short and kind of talk to some of my understanding of how the Chinese Communist Party engages in foreign influence.
Sorry, can I just interrupt for one moment, Mr. Josky? Chair, could I get you to mute if you aren't already, please? You are? Okay. We're just getting some terrible feedback here.
Okay. Hopefully it's sorted. But yeah, I really want to kind of provide a short overview of how the Chinese Communist Party combines essentially influence and interference. Not to make the point that this isn't a meaningful distinction. I think it has incredible value for explaining what's wrong with some of the things that countries such as China and Iran, as we've heard recently, are doing in Australia, but really to make the point that something that is influence-focused, such as the Foreign Influence Transparency Scheme, can't be treated as a separate part of government strategy to efforts to counter foreign interference. My background was really looking at United Front work by the Chinese Communist Party, and especially the sort of overt side of this. This is efforts by the Chinese Communist Party to build relationships, often in a somewhat open way, with individuals within China and outside China. And we've heard cases such as Huang Xiangmo, the Chinese property developer who was donating to Australian politicians while he was a member of several organizations run or guided or affiliated with the Chinese Communist Party's United Front Work Department. But since then, the new piece that I've tried to study and examine and investigate is really how covert work, the work of Chinese intelligence agencies, plugs into this visible layer of United Front networks. And what I've really seen is that from the very beginning of the Chinese Communist Party, back to the 1920s and 30s, this public side of United Front work has been deliberately and intensely integrated with covert and clandestine work. So you can find statements by party leaders from the 1930s talking about how they need to use the United Front to push forth intelligence, and they need to nestle intelligence work within the United Front. And that's certainly more so the case today than perhaps ever before, where there's an explicit integration of sort of seemingly legitimate and somewhat open United Front networks with the actual activities of Chinese intelligence agencies, such as the Ministry of State Security, which busy themselves with repressing dissent, but also stealing technology, stealing information from foreign governments, and seeking to change and influence our own political system and that of many other countries around the world. So you see, for example, seemingly legitimate exchanges through cultural ventures, through United Front organizations, through media activities, through business, integrated with the work of the Ministry of State Security and other Chinese intelligence agencies. And what this really means is that it's deliberately set up this way that the Chinese Communist Party engages internationally is deliberately set up to make that line almost impossible to draw. And that'll be, I think, one of the real challenges for the government in understanding how to tackle foreign interference is that there are agencies and there are many probably outstanding officers in the government who are experienced with countering espionage. But influence, I think, is something that governments are still struggling with and trying to get their heads around. And it's this integration of overt and covert work of, using seemingly legitimate activities to hide stuff that is clearly unacceptable, if not illegal, that really creates problems here. So thank you. I'm looking forward to this hearing.
Thank you, Mr. Joski. Much appreciated, and we appreciate your time today. I might just start by asking about that grey zone that we've been talking about and your thoughts on that, because there is this discussion about the influencing activity and how it sort of crosses over into a grey zone and then into interference. If you could talk to that for a moment, and whether you think the FITS in its current sort of iteration is catering for addressing activity within that grey zone, in your given the work that you've been doing.
I think one way to think about this is just how controlled and restricted civil society and society in general, in China in particular, is, where there are certainly no truly independent civil society organizations. In some senses, certainly in a sort of intelligence and security sense, there are no truly independent companies in China that are internationally engaged. They can be compelled by Chinese law under the national intelligence law to facilitate, cooperate in, and keep secret intelligence operations when asked to by the Ministry of State Security and other Chinese government agencies. So this means that you might have a Chinese business figure coming to Australia, or a business figure from another country to build relationships and to invest in Australia, but actually they're either acting at the direction of an intelligence officer or at the direction, or they themselves are an intelligence officer. Now, where I think this comes into the foreign influence transparency scheme is really the fact that it's clear from what the department has said, what other people have testified, and what other people have observed, is that it really isn't shining a light on these activities. That most of the stuff, in fact, the vast majority of registrations on there are things that are already transparent. And I think that, since the scheme has been in place for many years now, there's already a lot of awareness about the scheme and its objectives and people's requirement to register. And now essentially you've got a position where everyone who's willingly registered, like my former employer, the Australian Strategic Policy Institute, is already on there. And now there's this challenge of working out, I think, how to move it into an enforcement phase, how to use some of the more coercive powers, essentially, under the Act to actually shine light on this grey zone, shine light on foreign interference, and turn it into something that is no longer covert.
Thank you. I'll go to Senator Patterson. You had your hand up early there.
Thanks, Chair. Appreciate it. Thanks for joining us, Mr. Joski. I ask that you be invited to give evidence today because I consider you to be the foremost public expert on the United Front Work Department and its activities in Australia. And your recent book, Spies and Lies, also provides great insights to the work of the Ministry of State Security. I'm interested in your observations about the intersection between the Ministry of State Security and the United Front Work Department, or equivalents of either of them, and why we should be concerned about that. Because there are some people who say, the activities in the United Front Work Department are kind of, low-level influence activities. We shouldn't worry too much about them. Would you agree with that?
No, certainly not. I think the right way to think about it is that the United Front Work Department's activities are really concerning in their own right. I think its key focus is in Australia is meddling in diaspora communities, essentially. So trying to build Chinese government networks and access to people, ability to influence people within ethnic Chinese communities, ethnic Uyghur communities, ethnic Tibetan communities, and so on, probably with also some work in Taiwanese and Hong Kong communities. And this extends to trying to control and influence media that is consumed by those communities. So I've previously written about how really the media landscape for Chinese language in Australia is dominated by companies that are influenced or even in some cases clearly controlled to a substantial degree by the Chinese Communist Party. But I think really one of the most concerning aspects, perhaps on the sort of national level when it comes to the activities of the United Front Work Department, is that it's facilitating and in some ways providing networks and cover for even more sophisticated and concerning influence operations by agencies such as the Ministry of State Security that really specialize in professional, covert and clandestine operations. So you have the United Front Work Department building out all these networks in a way that it, isn't prohibited by law, building relationships with people across various communities who are aligned with the Chinese Communist Party. And the Ministry of State Security really sees that as a great operating ground, as a kind of a list of people who I think it would feel very comfortable approaching to recruit as intelligence assets and then tasking them to engage in covert political influence or political interference against the Australian political system.
And I guess...
Sorry, before you go on, Senator Patterson, there's quite a bit of feedback, I think, coming from Mr. Joski's computer. If you could just maybe turn your sound down a little bit, might take the crackle out of it, or if you have a headset, that might work. Sorry, Senator Patterson.
That's okay, Chair, thank you. And obviously one of the problems of the failure of these United Front work groups to register is that the people who are the recipients of their engagement are none the wiser. They, ordinary Australians may not know whether they're Chinese Australians or other Australians. And one of the virtues of them being required to register is that people at least be informed about their interactions with them, isn't it?
I think that's absolutely right. And especially now that, people have been sued for defamation, for exposing these kinds of links to the United Front Work Department and the Chinese Communist Party, that really gives the Foreign Influence Transparency Scheme, I think, quite a unique and important role in shining a light on United Front organizations, in kind of giving a degree of authoritativeness to those designations that, as an individual scholar is perhaps hard for me to give. And also especially when we have so many new parliamentarians, new members of state governments joining as well. I think that it's too hard for individuals essentially to be able to, on their own, identify United Front organizations. And this is not a function that has really been taken up by any agency in a comprehensive way. So FITS is going to be a really important, or should be a really important part of achieving that.
Yeah, and you're absolutely right to raise that issue, risk of defamation. I should note in asking these questions that both you and I are protected by parliamentary privilege. We can't be sued for anything that we say. Is it your view that there are active United Front Work Department organisations in Australia today, and can you list some of them that you're aware of?
I think a lot of it is becoming harder to track, and it's certainly, COVID saw them reduce some of their activities in some ways. But we can also see that COVID has actually created new channels for the work of United Front organisations. For example, an individual in Melbourne called Sonny Dong is being prosecuted for allegedly conspiring to commit an act of foreign interference that involved making donations around COVID and I think to hospitals. So there are definitely, I think, United Front work is ongoing in Australia. There are still organisations in Australia that have close links to the United Front Work Department. I think it's difficult from open source information alone to determine the exact degree of control that the United Front Work Department has over some. This would really be a task for people administering the Foreign Influence Transparency Scheme to investigate. But certainly in the past, you've had organisations like the Australian Council for the Promotion of Peaceful Reunification of China that have, very clearly in the past operated at the direction of the United Front Work Department or its officials. And then, once more light was shone on that organisation and, media reporting showed how individuals associated with that were engaging in foreign influence work in Australia, such as the former president of that group, Hong Xiang-mo, many of the individuals there really shifted to operating through another organisation called the Australia-China Economics, Trade and Culture Association, which is still very active and essentially has, much of the same membership as this organisation that has previously been exposed. This is a, an evolving problem that requires a kind of active, proactive response from the government.
Yes, and that other organisation you mentioned, the Australia-China Economics, Trade and Culture Association, has a kind of very obvious association with Chinese embassies and Chinese consulates. They organise joint events together. They're very clearly a group which is favoured by, the Chinese party state. So it seems strange to me that that's not evident to the Attorney General's Department and they can't pursue that. Moving on to one other related issue, the Attorney General's Department has recommended the committee consider the exemption that is currently granted to charities. I'd be interested in your view about whether or not that is something we should look at as well, particularly in light of the fact that people like Dr. Chow Chak Wing run a prominent foundation which appears to me to be engaged in a reputation washing exercise. He donates to highly sympathetic organisations in the community like veterans organisations, universities, arts, other groups, has his name plastered over a building at Sydney University, but has been accused in the federal parliament on 3 separate occasions by 3 separate federal members of parliament of being involved in foreign interference activities in Australia. Should we be allowing groups like that to be exempt from the law and immune from examination?
I think charities are really an important conduit for foreign interference, potentially. So there's a case study in my book of a charity in Shanghai that was actually established and is run and staffed by undercover officers of the Ministry of State Security's Shanghai Bureau. And these officers use this charity to receive funds from a Chinese Buddhist temple and also support this temple's engagement with Buddhist figures and monks around the world. So there's clear evidence of Chinese intelligence services using charities as conduits for covert and clandestine operations. Now, I'm not aware of specific cases of charities being examined under the Foreign Influence Transparency Scheme. My understanding is that there are certain activities that are sort of accepted for charities to engage in, but simply being a charity doesn't exempt you from, you can still engage in activities that would require you to register, just as long as they're not essentially part of the normal course of your operation as a charity. But I think it would be definitely important to consider that charities are a known conduit for intelligence operations and influence operations by the Chinese government.
And just finally on that, there's also an exemption for lawyers under the scheme, and Mr. Nick Xenophon, who's acted on behalf of Huawei, has asserted that his role as a lawyer exempts him from the Foreign Influence Transparency Scheme. I actually think the drafting of the legislation is more narrow than that, and it only exempts them when they're representing someone in litigation. And there's no evidence that Mr. Xenophon has ever represented Huawei in litigation, but he certainly has engaged with parliamentary committees and the media on behalf of Huawei. Do you think there's merit in looking at that exemption for lawyers as well?
Yeah, I think so, for the same reasons as it is for charities, that especially given the lack of real independent civil society and private sector in China, we have to be really aware of how all these things that aren't necessarily directly governmental, but nominally private companies such as Huawei, nominally private charities such as this one in Shanghai, can actually be operating as arms of the state, or at least instructed to carry out activities on behalf of the state. And if someone is doing that as a lawyer, I think that should still require them to register on the Foreign Influence Transparency Scheme.
Thank you, Mr. Joski. Thank you, Chair.
Thank you, Senator Patterson. Any questions from Canberra there, from Mr Hill or Senator Ciccone?
Mr Hill is not in the room at this point in time.
He's departed. All right, we'll move on to
I've got
you,
no questions.
Mr Wallace, do you have any questions?
I have no questions for Mr Joski.
Senator Birmingham or Mr Hastie?
I think Senator Patterson covered it all for me. Thank you. Thanks, Mr. Joski.
Thank you, Mr Joski. Thank you so much. I want to thank you for your attendance today. If there are no further questions, if you have been asked to provide any additional information of answers to questions on notice, the Secretariat will be in touch regarding timeframes for providing that to the committee. You will be sent a copy of the transcript of your evidence once it is available in the coming week, and you'll have an opportunity to request corrections to transcription errors. Once again, thank you very much for your time and your insights. Much appreciated. Thank you.
Thank you for the invitation.
Colleagues, our next set of witnesses, I'm not sure if they're there in the room there, Andrew?
No.
Not yet. We might just take a 5-minute break, stretch your legs until they get back. 5 minutes, colleagues. 5 minutes.
We might need a little bit longer because they're not due here till 2:30, Chair.
Well, we'll have a 10-minute break then. Even better.
Or maybe even 15.
Okay. Well, if people can be back at 25 past 2:30ish, or just before 2:30, I'm sure they'll be in the room by then, and we can get started. I'm going off to stretch the.
We're good to go here, Chair.
Good to go? Great, thank you. So welcome to the next set of witnesses that we have. If you could all just, for the Hansard record, please state your name, your full name and the capacity in which you appear before the committee.
Chris Teal, Deputy Director General of Security, ASIO.
Andrew Kefford, National Counter-Foreign Interference Coordinator, Home Affairs.
Anthony Coles, First Assistant Secretary, Counter Foreign Interference Coordination Centre in the Department of Home Affairs.
Thank you very much. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as the proceedings of the respective houses. Giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to a more broader discussion, if you have an opening statement.
Chair, I have a short opening statement, if it is okay.
Go ahead.
Thank you. Thank you for the invitation to appear before the committee today for its review of the FITS 2018 Act. I'd like to make, as I said, a brief opening statement. As you know, ASIO's role is to protect Australia and Australians from threats to their security. This role includes the threat of foreign interference. The term foreign interference is perhaps not well understood, and people sometimes confuse it with the term foreign influence. The Director General of Security noted in his annual threat assessment last year that foreign interference and foreign influence are two very different concepts. Foreign interference refers to actions that are directed by or on behalf of or in collaboration with a foreign power which either involve a threat to people or are clandestine, deceptive and detrimental to Australia's interests. On the other hand, foreign influence is when engagement or activities are undertaken openly on behalf of foreign governments. This activity is a normal part of statecraft and is not a matter for ASIO. Seeking to influence a decision by open lobbying or diplomacy for a foreign government is not foreign interference. ASIO only gets involved when influence activities on behalf of a foreign government become clandestine, deceptive or threatening and are detrimental to Australia's interests and therefore cross the threshold into foreign interference. That said, interference is not what we are here to talk about today. We're here to discuss the Foreign Influence Transparency Scheme Act. ASIO recognises that the scheme plays an important part in protecting Australia's interests by providing transparency. That kind of transparency is welcome in our democratic society. It is important to know what the scheme is not. It is not about interference and it is not about catching spies. The scheme and our espionage and foreign interference legislation are complementary. The scheme encourages transparency and is the first step to hardening the environment against interference. Separately, the espionage and foreign interference legislation supports the criminal prosecution of those undertaking activities that cause serious harm to Australia's national interests. Thank you, Chair.
Thank you very much. If there are no, are there any further opening statements?
No, thank you, Chair.
Thank you very much. Look, I might kick off. One of the things, having a look at all the evidence and the submissions that were put forward, I was actually interested in the topic around two things for Home Affairs. It might be you, Mr. Kefford, around the work of the role of the Counter Foreign Interference Coordination Centre and how that works within not just the overall CFI network framework, but also with the FITS. How does that combine or work? If you could talk to that. And then also, if you could touch on, in your submission, you touched on the fact that you work, or Home Affairs has worked with the Attorney General's Department in supporting the administration of the scheme. We've heard a lot of evidence about the implementation and the administration of the scheme and the sort of enforcement side of things being somewhat short. Could you explain what Home Affairs' role is in the administration of the scheme and working with the AGD on that.
Certainly, Chair. I'll start with the framework first. Obviously, the key components of the foreign interference framework the government put in place in conjunction with the 2018 legislation is the Foreign Interference Coordination Centre and the CFI Task Force. CFI Task Force is hosted by ASIO, ASIO-AFP, AUSTRAC, and it's responsible for the enforcement of the criminal legislation that Mr Teal was just referring to. In relation to the work of the CFI Centre and my role as coordinator, essentially what we do is bring together Commonwealth colleagues and increasingly state colleagues in relation to sharing of information and intelligence, sharing of good practice in terms of responses. I chair the UFIT task force, and I'm aware of the evidence that the universities groups have given to this committee in this hearing and at other times. And in that sense, while the focus of the effort is on the interference end of the equation, as Mr Teal has just laid it out, of course this is a continuum, and foreign influence and foreign interference are really two ends of the same stick. Foreign influence is something that, of course, is part of a vibrant and open democracy, and something that we would encourage. Clearly, across the whole of the work we do in relation to foreign interference, there are significant measures in place that go to transparency and openness, and as the Minister of Home Affairs has commented in her public remarks on this, in terms of supporting Australian values and the conduct of Australian political life in accordance with those values. The administration of the FITS Act, in particularly, to your second question, does sit with our colleagues in the Attorney General's Department, and so our role in that context extends to sharing and facilitating the flow of information to them and from them back into the broader conversations we're having about managing the whole of the issue. But we don't have a significant role in terms of the actual decision making that's made, under the authority of the Secretary inside the Attorney General's Department.
Thank you. I might see if I've got some hands up. Senator Patterson, and then Mr Wilson.
Thanks, Chair. I'll defer to the Deputy Chair if he's in the room and he has questions he wants to ask.
I can't see the Deputy Chair. I would have gone to him if I could see him. But
Is that why I'm feeling unloved, Chair?
Well, you're all the way in Canberra. Did you put? Oh, there you are. I can see you now. Senator Patterson, deferred to you, Deputy Chair. Do you have a question?
I do have some questions. Thank you, Chair. Mr Kefford, can you just explain to me, talking a little bit about the sharing of information between AGD and yourselves and you said state governments. Can you just unpack that a little bit about why is there a need for another organisation such as Home Affairs to be involved in that sharing of the information? Why can't, for instance, AGD do that themselves?
Well, in relation to the functioning of this scheme, Deputy Chair, that would happen if that were necessary for the AGs to do. My reference was more in terms of the broader work we do, both with the community members but also with state and territory institutions, sections of the bureaucracy, in carrying forward a discussion with them about what, and it's more in the realms of foreign interference than foreign influence, to be clear, what foreign interference looks like in the university sectors, amongst community groups, amongst parliaments, as well as through the state and federal electoral commission. So our engagement with the states from Home Affairs is much more in that foreign interference lane than it is here. If there were to be a discussion around the administration of the FITS Act as it is, then that would be something that AGs would do as part of their responsibilities for it.
You singled out state and territory governments. What interactions do you have with, say, for instance, the LGA? Because we know that where there has been some foreign interference and foreign influence, that descends down into the local government areas as well.
Yeah, I think I'd describe that, Deputy Chair, as an emerging part of our work. So the focus of the work from Home Affairs, when Mr Teal was originally in my position and over that period, has been really directed to the university sector because of the exposures and risks that were evident there, and so the work that's gone into through the UFIT process in the foreign interference guidelines for universities has been a key part of that. The second area of significant effort has been with the electoral commissions in support of the proper conduct of the federal and increasingly state elections, and really the next areas of focus for us in relation to foreign interference will be with the state and territory governments, including their local governments, and ALGA will need to be part of that conversation, of course.
We should sort of park foreign interference to the side, I think, for the sake of this discussion. Otherwise, we're just going to confuse ourselves.
Yep.
And try and, as important as that is, obviously, but that's not what we're dealing with today. Just going back to the UFIT, and you're personally the chair of UFIT. I don't know if you've had the opportunity to listen into the evidence that was given by the universities earlier today, but I'm keen to understand from your perspective what role you think UFITS plays, and whether does that, for instance, in your view, make, I'm playing devil's advocate here, does that make the FITS scheme redundant, for example?
The focus of the work of UFIT has really been on the two versions of the guidelines for addressing foreign interference in the universities sector. The benefits of that, and I've had a report of the evidence rather than hearing it myself, but
Right.
I'll speak on that basis. The real benefit for us, and indeed for the Vice-Chancellor colleagues who are part of that group, is the extent to which there is very open, very frank discussion. There's sharing of intelligence from ASIO, and it's genuinely a collaborative process that involves us working alongside universities, not just at the UFIT table, but there's a series of working groups underneath it, and that's the real strength of that body. Increasingly, that conversation, as it has matured, as the bureaucratic understanding, as the systems and the universities' understandings of the issues have matured, the conversation has expanded, and so we've started talking, in relation to foreign arrangements. We've had discussions at the UFIT table, the foreign arrangements regime. We've had discussions about the new Home Affairs arrangements for critical tech visas and so on. So again, building on the collaboration there. To the question about whether or not that renders foreign influence reporting redundant, in that sector, a lot of the issues are common. We've started at the foreign interference end because obviously that's where the greatest risk is. I think to have an ongoing conversation that traverses, and I suppose there's a parallel with foreign influence being a valued part of our democratic process, then academic freedom and engagement with colleagues, provided it's done in the daylight and in full knowledge of who we're dealing with and having done our due diligence, is one of the real strengths of Australia's education system and higher education system as well. The difficulty with saying that UFIT is the answer is that's a body that we have with the universities. And so it doesn't address other areas of the other sectors of the governments or indeed the economy that are equally or similarly exposed. I think what is replicable from that, though, and this is the approach that we propose to take, is the underpinning collaboration and cooperation at that table has delivered significant benefits in the university sector, and my sense is that it's that sort of conversation that will allow us to have the same sort of positive engagement with state governments and local governments as we expand those conversations as I've been describing.
Yeah, I probably mischaracterised it when I used the term redundant. I probably should have said, with the operation of the UFIT, do you see value in the FIT scheme being applicable to the university sector remaining?
The one element of the FITS scheme that provides great assistance in that context is the extent to which that it's a public transparency framework. The foreign interference guidelines are about university governance and decision making and due diligence and contracting, so it's not necessarily a public transparency mechanism in the same way. Mm-hmm. Inevitably, and as I've described it, it's the influence to interference is two ends of the same stick. How long that stick is a different question. So I think the approach we've taken at the UFIT table, Deputy Chair, let me answer it this way, is to certainly if there's opportunities for us to align reporting to alleviate a reporting burden from multiple schemes, whether that's FITS or the foreign arrangements or other things, that's a live conversation. So if matters are being covered off for the government, then what we're trying to do with our colleagues in Foreign Affairs and elsewhere is to say, well, can we streamline the reporting, streamline the discussion so that universities don't have to report multiple times, rather than saying necessarily, to the point of your question, should they be excluded from the operation of the particular schemes?
Sorry, my iPad is Siri's working overtime. Apologies.
Thanks. You got more questions?
I do, Chair. Yes, I do. So one of the themes of criticisms of the FITS has been that it's weakened by being country agnostic. Do you have a view on that?
It's a criticism that we've heard. I think the benefit of the country agnostic approach is it allows us to say, in effect, we don't like this behaviour, whether it's interference or influence, that's not properly, registered and declared. We don't really care where it comes from. We don't like it. The question then becomes: does that mean that we're not necessarily directing areas to the areas of greatest risk? I think that's one concern. I'd note in that context that the UK and their new legislation has in effect established a two-track process where there are both general obligations and there's the possibility or the ability for the government to declare particular countries as being of concern and apply a higher reporting threshold. So I think the danger with country agnosticism is it's not a shorthand for just one country, and I think it gets used that way sometimes. But I think no matter where we're having the conversation, of course, what we're ultimately seeking to do is protect and safeguard Australia and Australia's interests. And so there will be some areas and activities from some countries that are worthy of greater scrutiny, even if that's within a country agnostic approach, in the sense that we don't really care where the interference comes from, we don't like it.
Okay. Last question, Chair. The position of the National Counter Foreign Interference Coordinator sits in your department?
That's the position that I hold, yes, Deputy Chair.
That's your position. Yes. So how does your role differ from the body that the Chair asked you about? The CFICC.
So the CFI Centre is the division in Home Affairs that Mr Coles is the First Assistant Secretary of. So there's an organisational unit inside my group in Home Affairs that does the work, does the engagement with the community groups, with the colleagues, with UFIT. So the Foreign Interference Centre works for me in the same way that the Counter-Terrorism Centre works for me when I'm sitting in that role.
Okay, thanks. Thanks, Chair.
Thank you, Deputy Chair. Mr Wilson.
Thank you, Chair. Mr Teal, I think, began by saying that interference and influence are very different. I think, Mr Kepherd, you've perhaps acknowledged that while noting that they're nevertheless on a continuum. We've certainly had evidence that suggests that the part of the problem here is that influence can become interference, or that influence and interference can be practiced by the same entity. I mean, clearly the difference in all of the documents we get, all of the submissions from ASIO, Home Affairs and the AGs essentially say that interference is secret and improper influence. And the thing with a FITS scheme is you're trying to see influence in the first instance, just literally know where it is. To the extent that there's influence occurring and it's not transparent, then it's meeting one of the two key tests for interference, because it's secret, because we don't know it, or we're not seeing it properly. Whether it's improper, I guess, is the second part of it. We've had quite a lot of evidence that suggests that FITS is not being effective in allowing us to see influence that we should be seeing. So I guess my first question to both of you is, how concerned are you about that? Do you take that view? In your view, is FITS failing to show us influence, and because there's certain kinds of influence that we're not seeing, that could prima facie be foreign interference that we're not assessing in terms of whether it's proper.
I might start, and then Mr. Kefford, I'll throw to him. What I would say is that alongside this piece of legislation are the roles and functions of ASIO, specifically calling out foreign interference and our ability to apply our powers specifically to that, as well as an espionage and foreign interference legislation framework which we operate under. So it would be incorrect to characterise that our foreign interference activities are limited by the legislation governing the Foreign Influence Transparency Scheme.
Well, okay, I accept that, but we've got the submission here from Home Affairs that describes the FITS scheme as an important early warning system. So they've described it in that way, almost, and in fact suggesting that, they're acknowledging the importance of it as an early warning system, which I'm not sure is entirely consonant with what you've said, and also suggesting that one thing that could be improved is that Home Affairs could perhaps provide better guidance to the Attorney General's department, so that some of the identification of influence could occur better or more effectively by being better guided. So, I mean, I guess it's important for us to understand that either ASIO or Home Affairs believe that the ineffectiveness of the FITS, which is something that a lot of people have said to us, is a problem as part of countering foreign interference.
What I might, and I agree with what Mr. Teal just said in terms of saying, in terms of the framework in which ASIO operate. Two things I'd add, Mr. Wilson. One is that the other part of the interference definition is, yes, it's clandestine, but the other part of it is that it's undermining Australia's sovereignty and interests, and has that corrupting effect. The issue with, and it's being directed by a foreign power. The issue with influence and are we picking it all up? There's a maturity component to that. There's an element of, the ability to have greater transparency about the actions of people lobbying openly but on behalf of foreign entities is the underpinning reason why we have this legislation. That's a useful goal. It's a useful early indicator of the sorts of activities that could indicate something worse. The questions about whether there are questions, we've heard questions and have seen some of the evidence around the incentives for people to identify and other people who are registering the ones who would have done the right thing anyway. So I think there are questions there about are the incentives in the Act correct to encourage the right sorts of behaviour? But I don't think, while it is a warning, as we've said or warning source, as we've said in our submission, I suppose I'd also say it's not the only way that activities that are in fact foreign interference can be detected. It's not our only way to shine the spotlight on this activity.
Sure, I appreciate that, but I guess it's still like an answer. If it's an important part of the early warning system where we see influence that because we don't know it exists, we may not be able to judge its propriety. I mean, it could be a form of foreign interference that we're not aware of, or it could be shading towards foreign interference. We should know about that at the earliest possible time. If it's not working to show influence that everybody says is there, is that a problem from the point of view of agencies like Home Affairs and ASIO that are more responsible or are responsible for the sharp end of the stick that you described, which is foreign interference? Or is it just, or doesn't it matter? Because it sounds to me a little bit like you're saying the FITS is kind of good and it gets some things out into the open, but we know about it all anyway, so don't worry. But which is it?
Mr. Woods, I think it's fair to say that open and transparent influence and the ability to demonstrate open and transparent influence is a statement of a principle of a pluralist liberal democracy. And in that regard, the effectiveness of the scheme to be able to provide that open and transparent awareness is important. And I think that's the point here. And then on the other side of this is, of course, there's activity that if somebody was attempting to undertake foreign interference in this country, then they may choose not to register on the FITS as well. And therefore, there's an interesting scenario that we find ourselves in. So I think it's an important tool. It provides transparency in the democracy that we're in, but it's not our only. The powers of Asia and the role and function of Asia and the legislative, the espionage and foreign interference laws that the task force, the CFI task force, have access to, allow us to also work in areas that you'd expect us to be working in.
Okay, just a couple more questions, Chair. I mean, so that we just had the former Prime Minister saying the scheme is set up well, but it hasn't been administered properly. There are people who have been captured and being required to do things that probably aren't all that significant. There are certainly some big gaps. So to the extent that there are these big gaps, and Home Affairs and ASIO watch the FITS scheme in its administration, relatively stable number of activities, relatively stable number of principals, very, very little scanty use of the processes by which more information can be sought. Why is it that in the submission you've made here, you're saying that perhaps Home Affairs could be better guiding the AGD and its administration of a scheme that hasn't been working? Why are you only saying that now? Like, how is it that we've had this scheme for all of 2021 and all of 2022 when it was operating, with plenty of indications that it was ineffective, with plenty of indications that the mechanisms available to the Attorney General's Department to smoke out influence that everybody says is fairly obvious? If Home Affairs and ASIO are able to see that, why is it only now that there's a suggestion to this committee that you would better guide the AGD in using those mechanisms?
Well, Mr. Wilson, what I'd say in response to that is, first of all, the administration of all of the elements of the foreign interference framework, FITS, foreign arrangements, UFIT, the legislation, the task force, is a matter of ongoing discussion. And of course, as officials, we're interested in administering those schemes as well as we can, and providing advice, including on how that administration can be approved. I'm not quite sure, though, that the reference to saying, other than we're making a submission at this point, to the question about timing, why we're identifying this now, I'm not quite sure on what you're basing that part of it on.
It seems though you make the point that it is an early warning system. It doesn't seem to have achieved what it was intended to achieve. We've got lots of people, to call a spade, all of the references to United Front stuff, whether it's Mr. Joski or Mr. Turnbull, who was with us previously. So essentially there's this sieve that was applied to try and sort of show and bring kinds of influence that could be a concern into the light, and that hasn't worked. I'm finding it a bit hard to understand why, when what we want is an integrated, joined up national intelligence community, how it could be that Home Affairs looks at the administration of the FITS scheme over the sort of the early years, sees that it's not really doing what it was supposed to do, and certainly leaving some fairly obvious forms of foreign influence from countries of concern unidentified, and just sort of lets the AGD go along quietly in that ineffective approach, rather than saying, look, we can give you some advice, exactly as you put in this submission. We can give you some advice about how you can use your Section 45 and Section 46 and information gathering processes to actually do what this scheme is supposed to achieve.
I think there's two parts to that, Mr. Wilson. One is the as we have said, it's an important part of the framework, but it's not the only part of the mechanisms by which foreign interference comes to attention. So I don't necessarily agree with the assertion that it's being missed. Are there ways in which the scheme could be improved in terms of ensuring that it's focusing on areas of the highest concern, or that would assist in encouraging compliance with that part of it? I think the answer to both those questions is yes, and I think there's elements in the AG's colleagues' submission to this inquiry that point out some of those changes that might be made. But I don't think. Well, I don't agree that it's the case that the fact that to take the body that you've referred to is not registered under the influence scheme means that we don't know, and be careful in a public hearing, but that they're not known about and there's not other conversations and other activities going on in relation to them. So I think there's two questions. One is, do we have a good view? The other is, could this scheme be improved? And I think, in any scheme like this, there are opportunities, including through parliamentary processes like this one, to recommend improvements to how the definitions are established or how they might be applied.
Yeah, that's fair enough, and that's helpful, because it is important as part of this that we understand how all of these things work. It seems that part of your evidence is that while some people are getting very hot and bothered about the fact that the FITS scheme hasn't picked up things like the United Front, you're essentially saying, don't worry, we've got that under control.
Well, what I'd say is that we're not relying on FITS to identify that. I'll defer to Mr Teal in terms of the assessment. But I think it is... Look, the key part here is that the FITS is one part of a framework that addresses this sort of activity on a range of fronts, some of it through the criminal law, some of it through policy and guidance, some of it through education, and some of it through the activities of Mr Teal and his colleagues.
Mr Wilson, I just put a marker down about I'm not moving into in a public hearing an assessment of individuals or groups, and I don't think you'd expect me to do that or ask me to do that.
No, I mean, I guess the point I'm trying to get to is between some key agencies that have a shared task is whether or not, it's one thing if, from the view of ASIO and Home Affairs, the shortcomings that we're being told about time after time with the FITS are a problem. And if they're a problem, one of the things we might expect from a joined-up community that is coming together through things like the National Counter Foreign Interference Coordinator Centre is that there would be a sort of sharing of views and a joint effort on improving the whole holistic shebang. What I'm trying to understand is whether, in the view of ASIO and Home Affairs, the shortcomings of the FITS scheme are no big deal, or they are a big deal, and in which case it's a bit hard to understand why that hasn't been a more active conversation amongst the agencies with a view to getting it to do the useful early warning job or whatever other things it might contribute to the more specific tasks that you have.
Well, again, I wouldn't necessarily ascribe the value judgments to it. The point is that the conversations, first of all, our original submission of this is 12 months old. Secondly, the conversations to which you refer have and do go on, including when we have the formal coordination meetings amongst the agencies. But the point that I would emphasise again is that FITS it's an important part. The transparency that FITS brings is an important part of the regime, but it's not the only part. And so there are other ways in which, while, as I've said previously, it may well be possible, and this committee may well recommend improvements to the scheme and how it functions, it's not the only mechanism by which we're able to have this conversation amongst the relevant agencies.
Thank you, Chair.
Thank you, Mr Wilson. I'll go to Senator Patterson.
Chair, I'll direct this to Mr Teal in the first instance, but Mr Keffer and Mr Coles might wish to comment. Has the United Front Work Department packed up its activities in Australia and taken its bat and ball and gone home?
Thank you, Senator Patterson. As I said in a public hearing, I'm not going to go into conversations about individuals or groups, and I appreciate you'd appreciate the rationale for that.
Yeah, I mean, the reason why I asked the question is, as Mr Wilson alluded, it is a source of frustration and kind of bewilderment for the committee that a group which is widely known to be active in Australia and to be acting on behalf of the Chinese government and engaged in covert influence activities not only hasn't complied with the scheme, but that there appear to be, at least in public, no consequences for their failure to do so. No one has been charged. AGD hasn't used the powers that they've got to force them through that process of notices to register and be transparent in activities. So what can you say to the committee to reassure us that even though that form of transparency has not occurred, that groups like this have not escaped the scrutiny that they deserve?
Again, it's a statement of principle that I'll make, which is that the organisation is, as the Director General said at Senate estimates on the 13th of February, that espionage and foreign interference has supplanted terrorism as our principal security concerns. I think that tells a story, but I'm not going to provide any further information to that, Senator.
Okay. How about we make it a bit more abstract to make it a bit easier for you? If there is a group that is known to be engaging in influence activities but decides not to register on the FIT scheme, that would be of concern to your organisation?
Under the definition of foreign interference under the ASIO Act, I'd refer you to that, and also the espionage and foreign interference legislation.
But by definition, someone who's trying to wield influence covertly is committing interference, aren't they?
Again, I'll come back to those key data points, the ASIO Act and the espionage for roles and functions and espionage and foreign interference legislation, and perhaps people can draw conclusions.
Yeah, they might need a little bit of assistance to draw conclusions, though. Not all of them will be as familiar as you or I might be with the legislation and with the focus of your organisation. Let me phrase it this way. Is a group's non-compliance with their FITS obligations a data point that ASIO might use to put that group under greater scrutiny?
I think I'll come back to the point that from our perspective, foreign interference is clandestine, deceptive or threatening activity conducted on behalf of a foreign power which aims to affect political or government processes. We look at it through that lens, Senator, and that's enshrined in legislation, and that's how we view these issues.
I understand the constraints around it, Mr Teal. I'm not seriously expecting.
I'm glad you do, Senator. We've been together for a long period of time, so.
I'm not seriously trying to get you to put classified information into the public realm or anything like that.
I appreciate that. Yes, thank you, Senator. That'd be helpful.
For all of us. But what I'm just trying to do is, look, I know, and you can't say, but I know that ASIO takes its responsibilities very seriously and would be concerned if there are groups that are non-compliant with their FITS obligations. But I'm also concerned that some groups in the community think there are no consequences for them because this piece of legislation has not been enforced and they can engage in these activities without risk. And so all I'm seeking is just some reassurance that they would be misguided if they think that simply because AGD hasn't come after them that someone else won't.
Well, I think it's fair to say, and again, you know the organisation very well, is that where we put our resources is on the basis of prioritisation, and I can assure you that prioritisation is based upon threat, risk and harm, and I take that very seriously, Senator.
Thank you. I know you do, and I know your colleagues do, and I think that's probably the most that either of us can do in this public forum, so I'm grateful for those answers. Thank you, Chair.
Thank you, Senator.
Thank you, Senator Patterson. Are there any other questions from Senator Birmingham or Senator Ciccone or Senator Birmingham?
I have some additional questions, Chair. If everyone else is done that hasn't had a chance to
all done,
ask
yep.
questions.
Mr Wallace, go ahead.
Thanks, Chair. Gentlemen, Mr Daniel Ward and Peter Jennings submit that the FITS would be better delivered by the Department of Home Affairs as the department responsible for overall countering foreign interference, coordination and delivery in government. What would be the advantages and disadvantages of Home Affairs taking responsibility for the administration? I mean, I don't know if you heard Mr Turnbull previously or you've been briefed on his evidence, but I think it's fair to say he was none too pleased at the way that the Attorney-General's Department had been administering the Act. So there's a suggestion that you guys should be doing it. What would the benefits and disadvantages be of that?
Senator, I've heard. Mr Wallace, I've heard those arguments. Our response primarily to that is the way in which the administrative arrangements are designed is a matter for the Prime Minister and not something on which we would provide commentary. What I would say, though, is that inevitably in these conversations where there are a number of different interests at play, there both needs to be and there is in place robust arrangements for coordination and information sharing to ensure that that the various departments with responsibilities here are working in close cooperation, and that's not just within the portfolio with Mr Teal and his colleagues, but with AGs and DFAT. But ultimately, that matter sits with the Prime Minister.
It's a very diplomatic response, thank you. I'm still going, Chair. I'm just thinking of my next question.
I actually have
You follow up to that? Okay, go for it.
So, Mr Kevin, I'm going to direct my question to you, because looking at the Department of Home Affairs submission at clause 22, it actually refers to the Departments of Home Affairs and AGD are together considering the following options to support administration of the FITS Act by AGD. And it actually then has 3 dot points. Can I get you to take us through those dot points, particularly in light of the work that Home Affairs is doing with AGD to make sure that there is proper administration of the Act?
Can I just get you to clarify when you say add clause 22 of the submission? Page...
Oh, sorry, page 6. 6 of 7. Assuming I've got the same document that everyone else has, but yes, excellent.
Ms Andrews, I might take that question. The first thing I'd point out, and Mr Kefford referenced this earlier, is that the submission that you have was our original submission in sort of November 2021, so over 12 months old, and quite a bit has happened in the meantime, both in terms of the evolution of the threat environment and the response from agencies to the evolving threat. And again, picking up on evidence that Mr Kefford gave earlier, I think it's fair to say that across all of the at-risk sectors in terms of foreign interference that we're worried about, we're doing a lot of work across government, across interested agencies, but also with the states and territories increasingly to lift capability in a whole range of areas, whether that's with universities, whether that's in the community space, and Minister O'Neill is on the record last week referring to some challenges in that space in particular. And certainly the same is true in our discussions with agencies, including AGD on CFI. So, and we've got a pretty robust governance structure in place now between Commonwealth agencies on CFI. Mr Kefford chairs the CFI Executive Board. AGD is part of that. AGD is also part of the separate but related oversight board that sits above the Counter Foreign Interference Task Force that is led out of ASIO, but also includes the AFP, which is sort of the enforcement aspect. So I think the answer in summary to your question is that in terms of those 3 dot points, those governance structures that have evolved over the last year or so give AGD the ability to plug into various agencies of government where they need to pull out the information that they need to support their regime.
Mm-hmm. So I'm just trying to get a clear picture, understanding that that what you've said in relation to how these structures are set up is really a matter for the government rather than the department. Are you able to go any further in terms of saying whether or not what is currently in place is working in the best interests of the Australian people?
Ms Andrews, what I'd say is, without, I can't remember if you were in the room, I was saying before,
And I may not have been, and I do apologise.
At the risk of repeating myself, if I were, and please stop me, there are really two tracks here. One is, are there ways in which the current legislation could be improved in terms of definition to make it clearer the sorts of organisations that are of interest, or to get behind perhaps deliberately obtuse veils to who the lead is? So there's always those sorts of discussions. The other point I say about that is, in addressing the challenges and risks that are posed by foreign interference, influence that's not declared, transparency is a key part of this. The FITS, it's in the name, the FITS scheme is an important part of that, but it's not the only part of this answer. So across the whole of the system, and even incorporating the DG's overall threat assessments, there's a good understanding of what's going on and who's doing it, recognising the constraints Mr Teal's just referred to. At the same time, there's always opportunities to think, well, in the lived experience of this thing, as it's matured, as we've seen the way people have behaved, we think it would be helpful, and there's some matters in the AG's department submission that go to this sort of thing. We think it would be helpful if we change the definition of principle to get behind some of the perverse behaviour that we've seen. So the answer to your question, I think, is both yes, but we also need to not rest on our laurels and think everything's perfect for all time.
Okay, thank you.
Thanks, Ms Andrews.
Yeah, I'm done, Chair. Thanks.
Thank you, Mr Wallace. Thank you to the witnesses for... Oh, Mr Wilson, you do have one more question. We've just gone over time, but go ahead.
Yeah, sorry, Chair, just one more clarifying one. I mean, picking up the point that was made about when the submission, the Home Affairs submission was made at the end of 2021, and following on from Karen's questions, it sounds like some of the things that you're recommending there in terms of greater coordination and provision of what's described as enhanced strategic support have begun to occur, which is good. So perhaps if you could just confirm that. But on that point then, and not wanting you to give any specifics that you can't give, but the annual report in relation to the FITS scheme identifies 9 information gathering notices, 4 notices to people who may be liable to be registered under Section 45, and 5 notices under Section 46 requiring further documentation. So a very small number of requirements or notices that go to that information enhancing mechanism that exists under the FITS scheme. But are you able to say whether any of those actions to seek information were actually prompted by or guided by this new enhanced strategic support that you obviously thought would be better to assist the AG in the administration of the FITS?
It might be difficult to draw a direct one-to-one connection, Mr Wilson, on that. In terms of the application of the notices and so on, that might be a question better asked of Mr Newnham when he's at the table in a moment. But I think the point of the remarks we made in the submission as it stands before the committee is, as I say, reflecting the maturation in the arrangements, reflecting the observed behaviour. We identified some things where there could be, opportunities for better information sharing, both from what we're hearing, in our engagements with the community through our community liaison officers, as well as amongst the colleagues. But how that translates to individual actions, as I say, is probably best asked of the AG's department colleagues.
Well, that's fine. I mean, I'll put it one more time slightly differently, just on the off chance that you can help, and appreciating that you might not be. But bullet point 1 of the item number 22 on page 6 of the submission that Ms Andrews was referring to before says, strengthening the process for the provision of strategic advice to AGD so that it can best focus its effort on early identification of potentially problematic foreign influence, which may be a precursor to foreign interference. Now, that sounds to me very much like that advice is provided and it prompts AGD to use the mechanisms that it has to seek information or to suggest to someone that they should be a liable entity. I think it'd be very helpful for this committee to understand, on the basis that this is something that Home Affairs has decided to do to help AGD administer the FITs better, it'd be very helpful for us to understand if some of the information gathering, there wasn't much of it, but if some of it that did occur in the most recently reported period, that is 21 to 22, was actually guided by or prompted by this kind of enhanced strategic support. I mean, I'm not asking for specifics. I'm just asking whether any of that information gathering was actually prompted or supported by the enhanced strategic support that Home Affairs reckoned should be provided and would help the AGD administer the FIT scheme.
Well, I think probably the best way to answer that is why don't we take that on notice, Mr Wilson, and come back to you with details that go to that question you've just asked.
Thank you.
Thank you, Mr Wilson, and thank you for all of the attendees today. Thank you for your attendance. If you have been asked to provide any additional information or of answers to questions on notice, the Secretariat will be in touch regarding timeframes for providing that to the committee. You will be sent a copy of the transcript of your evidence once it is available in the coming week, and you will have an opportunity to request corrections to transcription errors. Thanks again for attending to each of you. Thank you.
Thank you, Chair.
Colleagues, we're just going to take a 10-minute break. I actually have to make a phone call, and I'm sure some of you might need to attend to a few bits and pieces, and then we'll be back at 3:30. Thank you. Welcome the representatives of the Attorney General's Department to give evidence at this public hearing today. For the Hansard record, would you each please state your full name and the capacity in which you appear before the committee?
Thanks very much, Chair. Simon Newnham, Deputy Secretary, Integrity and International Group at the Attorney General's Department.
And Celeste Moran, First Assistant Secretary, Integrity Frameworks Division, Attorney General's Department.
Parker Reeve, Acting Assistant Secretary, Transparency and Administrative Law Branch, Attorney General's Department.
Thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement if you have one before we proceed to a broader discussion.
Thank you very much, Chair. I would like to offer an opening statement, and for the benefit of committee members, it'll be really in three parts. The first is regarding the purpose of the Act itself, just a reminder of that, an overview of the operation of the scheme to this point, and then looking ahead opportunities to strengthen the Act from the Department's point of view. Chair, as you know, the Act commenced December 2018. It establishes a transparency scheme that supports the integrity of our democratic system by providing visibility of foreign influence in our federal government and our political processes. In our open democratic society, the government welcomes contributions from a wide range of perspectives, including from members of the international community. However, the government also recognises that influence activities undertaken on behalf of foreign governments in a non-transparent manner can result in foreign interests being prioritised over the interests of Australian citizens and Australian residents, and this in turn can erode public confidence in Australia's political and government institutions. So the Act takes a country-agnostic approach, recognising that first, all governments seek to influence issues and policies that are important to them, and that there can be substantive differences of opinion on policy issues, even with like-minded governments. And second, that the geopolitical environment and the issues over which foreign countries seek to exert influence can change rapidly. They're not static. For this reason, the scheme provides visibility of influence activities undertaken on behalf of all foreign principals for the purpose of influencing particular political or government processes. And providing transparency for the public and for decision makers is an important objective in its own right. And the scheme provides transparency of foreign influence in our federal government and our political processes for both the public and for decision makers. A key feature of the Act, as I've mentioned, Chair, is its role as a transparency scheme. And whether it's the FITs or other transparency schemes, they can play an important role in deterring and countering corrupt, covert, deceptive and clandestine activities, including foreign interference. This informs the Department's approach to administering the Act and our compliance strategy. And this approach also prioritises the investigation of foreign influence activities that are not inherently transparent and that are likely to affect Australian political or government decision-making processes. And to inform our prioritisation, we collaborate with a number of government departments and agencies, including colleagues who appeared before the committee just previously, to assist us to identify potential efforts to influence Australian government policies and processes in a non-transparent fashion. So part 2, Chair, is the overview of the operation of the scheme to date. The scheme is achieving, in our view, its purpose of providing transparency of foreign influence. And the key mechanisms in the Act are the Transparency Register, which requires people and organisations who undertake certain activities to disclose those details on a public register, and that's received 136,537 page views from just under 40,000 visitors since its establishment. Those statistics and others that I will use as of 1 February this year. And the notice powers that are available under the Act, Chair and committee members, are tools to assist in enforcing the Act and to cast light on non-transparent relationships. And to date, again, 1 February, there have been a total of 106 individuals and entities registered, covering 476 activities on behalf of 229 foreign principals related to 44 jurisdictions. We've undertaken more than 25 preliminary assessments and more than 30 investigations, leading the Secretary to issue 24 information gathering notices, 2 provisional transparency notices declaring organisations to be foreign government related entities, one of which became a final transparency notice. These measures are having an impact on resilience building by creating behavioural change. For example, the Department has observed some entities and individuals that previously engaged in foreign influence activities in a non-transparent manner have ceased to do so. Some entities and individuals have made the extent of their relationship with a foreign principal transparent, and others have integrated foreign influence considerations into their institutional policies and practices to ensure instances of foreign influence are registered. Finally, Part 3, opportunities to strengthen the FITS Act. The scheme has been effective in building greater awareness and transparency. However, as only the second scheme of its kind worldwide after the United States Foreign Agents Registration Act, it's perhaps not surprising that there are opportunities to improve aspects of the FITS Act based on practical experience to better enable the scheme to deliver on its transparency obligation and objective. We've made 2 submissions to the review. Our first submission outlined a number of options to improve the Act, in particular, recommending the transparency purpose of the scheme be reaffirmed, strengthening the enforcement framework in the Act, refining and tailoring the broader registration requirements that apply to former Cabinet ministers and recent designated position holders, and ensuring existing exemptions to registration obligations are appropriate. The supplementary submission, the second submission, provides more detailed options for the committee's consideration, as well as several additional options that have arisen in the intervening period. And in particular, that supplementary submission sets out options to amend the definition of foreign principal to more easily capture non-transparent relationships and arrangements, to improve the operation of the transparency notice regime, and to make a number of technical amendments to improve the scheme's functionality. The Department welcomes the committee's consideration of these options, and we look forward to answering any of the committee's questions today. Thank you, Chair.
Thank you very, very much for your opening statement. I might kick off the questions. You touched on a little bit in your own opening statement some of the statistical analysis, I guess, of the numbers of cases that you've dealt with, and I guess that could be described as some sort of success or example of success. But could you give us a couple of, within the constraints of a public hearing, clear examples of some of the successes of the FITS over the last couple of years?
Senator, I will certainly, Chair, I will certainly commence that, start that answer, but I will look to colleagues to come in a little bit behind that. What I could offer is, again, without going into the specifics, we have seen those things I mentioned earlier. We have seen some entities actually building in to their policies and their practices a recognition of the impact of foreign influence and building in effectively to their organisations' resilience mechanisms themselves. we have seen quite a heightened awareness of the obligations under the scheme, where at times the nature of inquiries to our hotline or to our email address have effectively led to a recognition of the obligations that apply to particular individuals and entities. And I could also offer, Senator, Chair, that a great deal of the success or the benefits of this scheme rest on proactive cooperation from stakeholders with us in registering under the scheme. So in many cases we're seeing that proactive registration without the need for the same level of lean-in from the department and government more generally. But I will just check with colleagues if they wish to expand a little bit for you, Chair. Yeah, I think that's probably a reasonable answer for now, Chair.
Look, there's been a lot of evidence around the administration and implementation of the scheme, and your submissions point to some of the administrative burden on the department, or make the argument that that's quite high. But before I go there, I want to see I want to explore where there is a connection between that administrative burden that you've highlighted and the issues around, for example, the definitions in the Act, which may hamper the ability for you to administer the scheme in a way that captures the kind of activity that you want to capture, rather than activity that's a bit more benign, like BBC interviews and so on. Yes. So let me just go to, bearing in mind this issue around administrative burden, but go to the definitions. Your submissions are very detailed in putting up a number of options around broadening the definition of what a foreign-related government entity is, or a foreign-related individual, broadening those definitions to better capture the activities that they undertake if they're foreign businesses and so on, and also the scope of the activities being broadened by lowering the threshold potentially of the requirement for it to be a substantial or total control of that activity by the foreign principal. Could you, in your view, would changing those definitions or broadening them reduce the administrative burden? Wouldn't it actually increase it in the sense that you'd have many more entities that you'd have to chase down and follow through on?
Thanks very much, Chair. I appreciate the question. Let me start with an acknowledgement that we are absolutely operating, as you would expect us to, inside the parameters of a piece of federal government, federal legislation passed by Parliament. And so we take very seriously the evidentiary thresholds that exist there and the elements to findings that we require to be made for us to enact enforcement, for example, underneath the framework. That can be particularly labour intensive where the nature of relationship between entities is opaque, where vast volumes of documentation is provided but needing to be translated, for example, where there is a lack of cooperation by entities and limits then to the sorts of actions that we can take. So within those parameters, Chair, I can say that we move as fast as we can through what I would describe as complex casework, making sure that we meet those evidentiary thresholds at every stage through the requirements of the Act. What I would say, Senator, exactly to the point, Chair, exactly to the point that you made, it is resource intensive then to try and unpack and join the nature of relationship in those sorts of circumstances. And so the suggestions that we've made around the definition of foreign principal, and we've given two options here. Option one being adjustments to the definitions that exist on foreign government-related entity, company governance and management structures, also on the scope of paragraph C of that definition to legislate to embed political control or influence in entities and better reflecting the way that that can occur. And thirdly, extending the definition of a foreign government-related individual to cover Australian citizens and permanent residents. That option one, we do consider would would reduce the workload required for some of that casework. Option 2 would go even further in terms of the expansion of the entities that would be covered, but it would make that threshold, to our mind, easier to reach, but it would add, on the other end of it, additional burden in terms of administering a scheme that would attract actually quite a number more registrations.
Well, just on that point, because this is a bit that I don't quite understand, you're saying that option 1 would reduce the administrative burden. Wouldn't expanding the definition to be inclusive of more entities, effectively, actually increase your administrative burden? And I guess the related question is the current resourcing that you have adequate to meet the requirements that you currently have? And if you were to broaden it, like we've just been discussing, would you need more resources? Would you need more, people to help you get through the administration of the scheme?
Thanks very much, Chair. Exactly as you've mentioned, we have made the point in relation particularly to option 2, towards the end of that opening part of that section on page 9 of our submission. There would be resourcing implications for administration of the scheme, noting the increase in persons covered by the scheme, and that would need to be considered. But what I would say, Chair, is, of course, and it precedes all of the people at the table's time, but the scheme was structured in such a way that costings were made according to the nature of that legislative scheme and the resources that would be required to implement that scheme. It has proven to be the case that, as I said, in relation to those opaque relationships which we are seeking to better understand and gather the evidentiary base on which the Act rests, that does take quite a bit of resources, and so freeing up some of those resources is a net gain. But equally, to your point, there would be resource implications for that wider lens that would apply under either option 1 or 2. But I would say under option 2 it would be more acute. But I will just check with colleagues if they have anything to add.
The one point I might make, Chair, just on the sort of the relative increase or decrease in the resourcing requirement to undertake investigations. I think as we've set out in our submission at page 4, the definition of foreign government-related entity in particular has some quite objectively determinable elements to it. That's things like the company structure, its ownership, the application of foreign laws to it. Those elements are generally relatively simple for us to establish and for potential registrants to establish when determining whether they have obligations under the scheme. We've identified some areas where we think those elements of the definition could be improved. And I think to the extent that those elements are improved, that will bring more matters under the scheme into that reasonably straightforward, simple to administer, simple to investigate, simple for potential registrants themselves to determine whether they have obligations under the scheme. Where our investigations tend to become quite complex and resource intensive, and I think this is something that Ms Manstead addressed to an extent in her evidence this morning, is where we are seeking to establish informal relationships of control, particularly under paragraph B of the definition of foreign government-related entity, where we're not looking at the actual, either laws or constitution of a company or the composition of its board or its shareholding, but on the actual practices of people involved in that entity to determine whether they are under a formal or informal obligation to follow the directions of a foreign government or are accustomed to follow the directions of a foreign government. That is quite intensive to do. And so I think improvements to the definition to minimise the number of cases where we need to seek to rely on those elements of the definition will simplify the administration of the scheme, and then improvements even to those informal elements of the definition I think will assist in investigations as well. So that we may get more cases coming in, but a number of them would be simpler for us to address.
Right. So looking at the current operation of the scheme then, in that context, we've got a lot of evidence talking about how, pointing to how registration is done for registration's sake, for want of better phrasing, and frankly, self-reporting doesn't quite capture those entities or individuals who are obviously deliberately trying to avoid registering because their type of influence is malign or is coming through an authoritarian state. So would you, and I think you do have this in submission, do you support then a future like reform in which, if the government were to do this, give power to the secretary or other authority within the department to be able to register an entity if they are satisfied that the evidence is such that they meet the requirements to require registration?
Thanks very much, Chair. The answer to that is yes. We do support, and it's, we hope, fleshed out adequately for the committee in our submission. We do support graduated compliance mechanisms to be added to the existing framework. In particular, we would support, which doesn't currently exist, the ability for the Secretary of the Attorney General's Department to be able to register individual entities and individuals on the FITS register. Moreover, we would also offer the committee the option of registration of entities where they've been identified as being non-compliant with their obligations under the Act. At present, there is not that form of what I would describe as somewhere in the spectrum of action that can be taken underneath the scheme. Of course, there are criminal offences in rare and serious circumstances under the Act, but there is nothing short of that apart from the existing Section 45 and 46 information notices, as well as transparency notices as well.
Thank you. I have quite a few more questions, but I might only ask one more just to give colleagues an opportunity. My last question, and if there is time, I might come back to the rest of my questions. Again, looking at that, the issue that come to us obviously through various submissions, but also in the hearings today, when we're talking about your resourcing being stretched, I'd be interested in your view around why, in implementing the scheme, you're following up on, for example, writing to former Prime Ministers, spending that time and effort when they've done an interview or a speech and so on. Couldn't that time be better spent on, going after, I guess, some of the more egregious elements from various actors rather than what is already transparent?
Thanks very much, Chair. And whilst I won't go through it in great detail, if anyone would like the statistics around the current funding, the levels of staff allocated to this work and the approximate time taken for the complex casework, very happy to run through that. But to go specifically, Chair, to your question, I would make a number of observations. The first is that since mid-2021, there has been a concerted approach to former cabinet ministers and designated office holders, whereby we are focused on registrable activities under the Act, where there is substantive ongoing relationships with the foreign government or other foreign principal, and that's consistent with the compliance strategy which we've put on our website. And of course, wherever there are inquiries made by former cabinet ministers and of course former prime ministers, we absolutely do our best to assist with providing clarity there. But your point, Chair, is well noted, and indeed one of our suggestions for changes that may be made to this scheme is to have adjustments to the obligations on former office holders, and particularly here I note to have an exemption apply where the foreign principal involvement is apparent, where it is absolutely on the public record the nature of that engagement, and where the activities are not for political or government influence. Equally, Chair, I would note a suggestion that we could reduce the timeframes that apply both in relation to former cabinet members but also designated office holders. And you may be aware, Chair, that was actually part of the original bill that was presented to Parliament and the subject of consideration by this committee. So we would agree with the sentiment behind your question.
Thank you very much. I'm going to now defer to Senator Patterson for his questions.
Chair. I appreciate that. Mr Newman, thank you for your evidence this afternoon, and thank you in particular for the department's supplementary submission. I thought that was quite helpful. I think there's a number of suggestions there that the committee can quite easily adopt that I hope will improve the administration of the scheme and make the legislation work better for the department. Nonetheless, I'm still interested in examining why it is that the FITS scheme hasn't worked as intended, and I think we can say that with some confidence given that the former Prime Minister who introduced it, Malcolm Turnbull, says it's not working as he intended it to. So I guess a simple and straightforward question is, why is there no United Front Work Department entity on the FITS scheme?
Thanks very much, Senator. I note, of course, the previous comments made by colleagues, both from Department of Home Affairs and from ASIO. And what I can say, Senator, is, as you may be aware, the success of this scheme rests not only on operating inside the parameters of that piece of legislation as they were presented to the department to administer, noting, as I said earlier, we take very seriously our obligations, our evidentiary standards that we have to comply with under the elements of the Act. But it also rests on a great degree of cooperation and coordination with colleagues across government who administer other schemes or who bring a level of expertise about cross-cutting issues that are relevant. So whether that be on foreign interference or foreign influence or foreign investment or foreign arrangements, there will be inputs into that work that is cross-cutting, that it's incumbent on us, for example, to be involved in the university's foreign interference task force, equally on electoral integrity issues as well. And that's sort of the more formal end of it. And at the less formal end of it is a great degree of information sharing that goes on there. And whilst I wouldn't go into any casework of any nature, Senator, what I would say is we are constantly reviewing the pieces of information that come to us. We are comparing it then to obligations that exist underneath this current framework, and it also informs, I might add, the suggestions we've made to this committee for reforms. Moreover, it sits underneath our compliance strategy, which in its most simplest form focuses very much on the most significant risks that we are seeing in our system, coupled with what we would identify as efforts to be non-transparent about significant influence that may exist. Putting those together and focusing our resources under our compliance strategy on those sorts of that sort of casework.
Yeah, the reason why I asked is we have evidence from Mr Turnbull that the United Front Work Department was one of the primary targets of the legislation when it was introduced, and we had evidence from Mr Alex Josky, an expert in their activities, who said that they are active in Australia today, and he identified two front groups that operate on their behalf, the Australia Council for the Promotion of the Peaceful Reunification of China and the Australia-China Economics Trade Culture Association. The scheme's been in operation for 4 years now. These were targets of the scheme. None of them are on the scheme. Why not?
Senator, I would just offer that, of course, I wouldn't speak to the conduct or alleged activities of a particular entity or organisation, but what I would say is, of course, as I said earlier, this is a framework and a scheme that sits shoulder to shoulder with other frameworks and resilience schemes across government. And it may well be that the activities of any entity enliven the sorts of issues that you're concerned about under other frameworks. What I could also offer you is that we are operating inside the parameters of that piece of legislation passed by the Australian Government, which requires that there be registrable activities, which under Section 20 is parliamentary lobbying, under Section 21 is activities for the purpose of political or government influence. It needs to be on behalf of a foreign principal, which can be a government, a party, a foreign government-related entity, or a foreign government-related individual, all of which are defined in the Act. It's required to be for the purpose of political or government influence under Section 12, and it's required to have no exemption in place. So, Senator, I don't mean to belabour the point, but these are the requirements that we need to meet for us to take action inside that framework. And within those parameters, that's where we're operating.
I do understand that, and that is one of the reasons why I said up front, I think some of the suggestions you've made to reforming that Act are welcome, because I appreciate that that's a lot of hoops for you to jump through, that takes a lot of time to jump through those hoops, and that there may be an entity that only fails one of those tests and therefore falls outside the scheme. And that is, I don't think that was the intent of the Parliament. And so if we have to fix that, we should fix that.
Yep.
But just specifically on those two organisations that I named, can you say whether or not you've used your information gathering powers or issued any notices to those two organisations?
Senator, before I answer that, could I just ask you to repeat? I got the United Front Workers' Party, but could you mention the second one?
Sorry, so the two organisations are front groups on behalf of the United Front Work Department. They are the Council for the Promotion of the Peaceful Reunification of China and the Australia-China Economics, Trade and Culture Association. So it's the APPCR and the ACETA.
Senator, thank you. Whilst I feel I've given an answer on the first, I think what I can say about the ACCP, the Australian Council for the Promotion of Peaceful Reunification of China, I'm sorry, I'm getting the acronym wrong.
It's all right, it's complex.
Yeah, indeed. On the 9th of January this year, the Secretary of the Department issued a provisional transparency notice in relation to that entity, declaring it to be a foreign government-related entity. The ACPPRC is an organisation aimed, of course, as you know, Senator, at promoting the unification of China and Taiwan in Australia. It has attracted public scrutiny. The ACPPRC provided a submission to the Secretary about the provisional transparency notice. Following consideration of that submission, the Secretary remained satisfied that that body was a foreign government-related entity. And on the 6th of February, that provisional transparency notice became a final transparency notice, the first under the scheme. The transparency notice provides literally transparency about the fact that that body is related to a foreign principal. It also provides clarification for persons who may be undertaking activities on behalf of the ACPPRC that those activities may be registrable under the scheme.
So just confirm when that first notice was issued.
The provisional transparency notice was issued on the 9th of January this year.
Of this year?
Yes.
So that's very welcome, and I think that's important that that's now on the public record. But obviously this scheme was legislated in 2018, and this is a notorious group which has been on the public record for a decade. I mean, Wang Zhangmo, infamous for his involvement with Sam Dastyari in 2016 and 2017, it was a founder and head of this group. Why did it take almost 5 years of operation of the scheme for the department to exercise its powers to issue notices and make declarations in relation to this group?
Senator, I would not speak to the specific circumstances of any group, the time taken to analyse its activities or make judgments about that. The groups that you've mentioned, or indeed others that may be the subject of casework by the department underneath the scheme. What I can offer, though, is the statistics I mentioned in the opening statement on behalf of the department that goes to a great number of registrations across a great number of jurisdictions and activities, the vast majority of which actually rests on voluntary notifications and registrations by the vast majority of registrants. I can also offer that in terms of statistics, and colleagues can speak to this more broadly, the vast majority of registrations do cover entities linked with China. In terms of the top jurisdiction that we are seeing under the registrations under the FITS, China is quite clearly number one with 130 registered activities currently.
So, look, I do welcome that. I think it is important that these powers are being exercised and it's happening in relation to this group. But I do feel in relation to this particular group, it's almost like shutting the gate after the horse has bolted. Because of this group's public notoriety, there are many experts who say it's now what used to be the preeminent United Front Work Group department in Australia is now no longer because of its notoriety, and others that are less obvious, like the other group I mentioned to you, the Economics, Culture and Trade Organisation, ACETA, have since supplanted it as the primary mechanisms for the United Front Work Department to exercise their influence. So if we're now just, getting to a group that was notorious 5-6 years ago, there are new groups springing up all the time that have, innocent-sounding names but are engaging in exactly the same kind of covert influence activities. When are we going to get around to them? When are you going to issue a transparency notice for a CETA?
Senator, what I can offer is, of course, as I said earlier, there may well be, and I don't speak to the circumstances or the particular specifics of any individual case, but what I would offer is that conduct by entities may be the subject of foreign influence transparency scheme, but they may also be the subject of attention under different frameworks by different agencies across government. What I can also offer here is, and it was sort of the point made in our opening statement, this is a transparency scheme. It goes to, on the spectrum of activity, it goes to what would otherwise be deemed legitimate activities that, in fact, multiple governments engage in, but the expectation is that those activities be transparent. And it's where that those activities are not transparent that this scheme seeks to operate. So I understand the frustration that you're expressing about the time taken, and again, all I could offer you there is within the parameters that we are operating, we are working as fast as we can. We are prioritising, as I said earlier, the situations where there is a concern about lack of transparency, coupled with the highest risk activities. And here I would particularly point to where that activity is geared to or focused on a particular decision or a political process, or indeed goes to systemic and sustained failure to comply with the obligations under the FIDS.
Yeah, look, thank you. I do understand that point, and I think you also understand the point I'm making. So I just want to move on to a separate issue, which goes to that question of resources that you flagged. How many people are currently working in AGD on the FIDS scheme?
Please.
Senator, we have 8.2 FTE working on the FIDS scheme.
Okay, and how many people in that in total?
Sorry, Senator, can you repeat the question?
As in non-FTE, right? FTE is a measure of people's time that they contribute to something. How many is the total number of people working on it?
Well, Senator, we have, so yearly, 2.2 million is provided to the department to administer the scheme. We have one team that deals with not only the FIT scheme, but the lobbyist code and the register associated with that.
My question is really very basic. FTE might include 8 people who are working part-time and 4 people working full-time, and that might add up to 8, and that might be a total of 12 bodies. I want to know the total number of bodies, not just the FTE.
It's the 8.2. Is that right, Parker?
That's not possible, right? No. You can't have 0.2 of a person. It would be 9 people, or...
I beg your pardon, Senator. No. So the Transparency Framework section, which looks after both the Foreign Influence Transparency Scheme and the Lobbying Code of Conduct, has a total of 13 staff. Some of those staff do, of course, split their responsibilities across both schemes.
And that's what I want to get to. Okay, so total number of people is 13. Full-time equivalent is 8.2. How many people are exclusively working on this, only on FITS and not on any other jobs?
Not on any other jobs, Senator? I mean, all staff will, of course, provide input to regular just departmental coordination, briefing.
Yeah, but there's substantive roles, what I mean.
Yeah, certainly. I think, Senator, I'd probably have to take that on notice, only just because we've just gone through an internal restructure around responsibilities within that team. And so I just want to make sure I've actually got the right numbers in terms of who is working in a dedicated fashion on it.
Thank you, that's fine. On notice would be welcome. How many of them are Mandarin speakers?
I think I'll confirm this if I'm incorrect, Senator, but we have 2, I believe, fluent Mandarin speakers in the team.
Good, thank you. In your opinion, is this a sufficient amount of resources to be working on this issue, given that the Director General of ASIO says that foreign interference and espionage is our principal security concern?
Well, Senator, I mean, any question that goes to resourcing, of course, has to be seen in a wider context. But if your question is, would greater staffing and resourcing assist with our administration of the scheme, the answer is yes. We could, of course, use that type of resourcing on engagement with potential registrants, increased awareness raising and enforcement. But, Senator, I would just caveat that by saying we've been given a budget allocation, we've been given a number of staff. I would actually also acknowledge that in addition to that comes IT system support, legal advice that we would get from colleagues, etc. So I guess where I'm going with this, Senator, is I think if you asked any part of government, could they do more with more resources, my guess would be they would say yes. So our answer to you is yes, but it's acknowledging that there are a range of pressures on any part of Attorney General's department, and we allocate them as best we can. Yeah.
I understand that. The reason why I'm asking is the theme of the evidence we've had from a number of witnesses is that the administration or the enforcement of this scheme has failed, and we can make recommendations as to legislative change, but it is also open up to us to make recommendations that the team is not of sufficient size working on this project. So this is not a reflection on anyone in the team. In fact, the opposite. It's recognition that this is a big job and there might not be enough people working on it. Of those 13 people, how many of them have experience in investigations? How many of them have a professional background in investigations? You may need to take that on notice.
No, Senator.
Yeah, if you could, that would be good. Sorry, Senator Patterson, just as we're running out of time, so if other colleagues might want to get their questions in. Could you take that one on notice?
Certainly, Chair.
Thank you.
Okay, thanks, Chair.
Thank you, Senator. Mr Wilson.
Thanks, Chair. Look, I've really just got two questions. As Senator Patterson said earlier, former Prime Minister Turnbull and also Mr Joske strongly suggested that the FITS arrangements haven't been administered as expected, and Senator Patterson gave, I guess, an example of that by referring to some particular organisations that Senator Patterson said, there would have been a strong expectation over the last 3 or 4 years that those organisations would have been picked up and looked at under the FITS arrangement. So I guess I'm just interested then, to the extent that that's put as a widely held and obvious view, including by members of the former government, was that something that was raised with the department by either of the former Attorney Generals, Attorney General Porter or Attorney General Cash?
Yes, thanks, Mr Wilson. Look, I think just in a straw poll quickly with colleagues, I think that's the sort of question we would take on notice. It goes back some distance, actually, as you would appreciate. I could certainly speak to some of the reasons why investigations don't result in registration or transparency notices, but I'm not sure if that provides an answer to your question.
Well, I think you've covered that fairly well earlier. I guess what I'm trying to reconcile is that Prime Minister Turnbull, who presided over the creation of the scheme, and members of the former government that are part of this committee have expressed this strong bewilderment about why the scheme hasn't been administered as expected. And they've given some examples of the kind of things that they would have thought were really obvious that ought to have been looked at more closely and been the subject of notice powers, like the ones you said were used just recently. Yeah. So I guess one of the things I'm interested in, and please, if you wouldn't mind taking on notice, I'd be surprised in the circumstances and the way that those views have been put. If one of the former Attorney Generals in the years 2019, 2020 or 2021 hadn't raised that with the department directly, because it seems to have been both something that was staring people in the face and a matter of concern. But I'll let you take that on notice. My other question is, we had Home Affairs and ASIO with us previously, and the Home Affairs submission that was provided as part of this inquiry at the end of 2021 talked about the way that different agencies could work better together. And in relation to the FITS scheme, that submission suggested that Home Affairs could perhaps help the Attorney General's department use the FITS scheme to in its sort of early warning guise to identify those practising foreign influence better by providing you with enhanced strategic advice. So I guess I'm just asking, has that occurred? Have they been providing you that enhanced strategic advice? And more specifically, was the use of notice powers in the most recent reporting period on any occasion essentially prompted by or aided by the provision of that advice from Home Affairs?
Thanks very much, Mr Wilson. I appreciate you've asked us to take on notice the reference to frustrations from others regarding the administration of the scheme. I would just note for the benefit of the committee, I'm sure it's well known, that there were, of course, key changes made to the bill that was originally proposed. So the bill that was originally proposed was adjusted in terms of the definition of foreign principal, which was narrowed as part of the assessment of that bill by this committee and indeed passed by Parliament. So too the scope of activities that were covered were narrowed. So too the definition of communication activities were broadened. The application to cabinet and designated office holders' positions were broadened, as was the time period applicable. Transparency notices were added and further exemptions were added in relation to registered charities, industry bodies, artistic purposes. So, Senator, I don't want to repeat the same point, but I will just make again, within the parameters that we are operating, we are doing our very best, and I know there'll be colleagues watching this. They are committed public servants seeking to administer this scheme the best possible way that they can. So I just wanted to put that on the record, and there are a number of reasons why an investigation wouldn't result in an outcome. There could be an investigation that's ongoing.
And I'm not for a moment, none of us, and I'm certainly not for a moment impugning the work of anyone involved. My specific question actually is to try to see whether either of the former Attorney Generals communicated what seems to have been a strongly and commonly held view amongst members of the former government that this scheme wasn't being administered correctly. So if you wouldn't mind taking that on notice, it seems that it would be hard to reconcile some of the views that we've heard both from the former Prime Minister and some members of this committee with that not occurring, and I'm interested to know if it did.
Indeed. No, thank you, Mr Wilson. I think the second part of your question went to the nature of the engagements with other departments, and noting Home Affairs and ASIO appeared before us, but of course I wouldn't ignore the other schemes that exist across government, including Foreign Affairs and Trade on foreign arrangements, the Treasury Department on foreign investment, and of course things like defence exports and sanctions that exist elsewhere as well. What I could offer, Senator, and I wouldn't necessarily form a view about enhanced engagement, but what I would say is we do consider one of the most beneficial aspects of the FITS and its operation is the way in which we engage with colleagues across those other departments that have responsibility for those frameworks. And I particularly note here the high degree of visibility we have of the work of the Countering Foreign Interference Task Force, and particularly inside the UFIT, the University's Foreign Interference Task Force, which of course we are a standing member of. So too the Electoral Integrity Insurance Task Force, where we are a standing member of that as well. We regularly share information across the scheme, both inwards for our own benefit in judgments under this framework, and outwards for colleagues administering other schemes. To your question specifically about how much I think your phrase was something along the lines of that enhanced engagement has led to specific outcomes. Mr Wilson, I wouldn't go into any specific cases and the circumstances of those, but what I would say is that those group of folks that are committed to applying this Act appropriately have a number of inputs. They might come from other departments. They might come from media reporting. They might come from the hotline that we administer, or email inquiries, and those are taken together, as well as our engagement with UFIT or the Electoral Integrity Task Force, whatever the form might be. A bunch of those inputs form then the work that we take forward, whether it be a preliminary investigation or an actual investigation.
I appreciate that, but I do want to put this to you. So Home Affairs have said that they contemplated providing enhanced strategic advice to AGT for the purpose of helping AGD administer its notice powers, administer the scheme. So while I'm not asking you to give me any specifics, and I hear what you said about all of the various different inputs, I would like an answer as to whether that's occurred. Since that submission was made to this inquiry at the end of 2021,
yes.
So from the beginning of calendar year 2022,
yes.
Has Home Affairs been providing you that enhanced strategic advice, and has it guided the work of AGD in administering the FITS scheme?
Thanks very much, Mr Wilson. The answer to that is yes. What I can't comment on is what that engagement was like at that point, but I can certainly offer that our engagement with Home Affairs is a key feature of our work here.
Just one final question, because what you said before about the way in which the the legislation was changed and narrowed was an interesting point. I appreciate all the different aspects that you explained. Ministerially, who drove that?
Senator, I'm not... Sorry, Mr Reeves.
Mr Wilson. During the parliamentary process, and I think Mr Hastie was on the committee at the time, and so would recall, the then Attorney-General, Mr Porter, wrote to the committee with a set of proposed amendments. That was during the course of this committee's inquiry and review of the then Foreign Influence Transparency Scheme bill. The committee, as I recall, then considered those proposals and adopted recommendations as to whether or not those proposals should be accepted, amended, or taken in a different direction.
So Attorney General Porter essentially put propositions to the PJSIS. I wasn't a member at the time.
No, yes.
The committee considered those and adopted them entirely, recommended that they, as proposed by the Attorney General, recommended that they be part of the narrowing of the legislation.
I wouldn't want to try and, I'd probably have to take on notice the exact answer. My recollection is that the committee recommended adopting at least the majority of the proposals put forward by Mr Porter.
And the committee obviously wasn't put to the committee on an open basis, as in tell us some of the things that you might do. There were some specific propositions that Attorney General Porter put.
Yes, indeed, Mr Wilson.
Okay. Thank you, Chair. That's all I've got.
So I'm acting chair at the moment. Mr Khalil's just had to step out for a minute. So,
thanks, Acting Chair.
Ms Andrews.
Thank you very much. Look, I do want to pick up the process. So I actually have in front of me this page. It doesn't seem to be numbered, but it actually sets out the process and the time frame to undertake an assessment under the FITS Act. And it probably goes to the information that AGD receives, and I think you've started to touch on that. So at the first point, in terms of identification, I'd be interested in you expanding on that in terms of the sources of the information that you receive by way of agency and department that could lead you potentially to go down an assessment path. So I'm not asking for information about any one particular issue. I'm more interested in the process of how you would get that information. You indicated before that you don't tend to lean into this. Many organisations provide the information that you need. Raises the obvious question, how do you make sure that you pick up those that have not been forthcoming with information? So it seems that a good starting point is the identification at one as to how you start to gather that information.
Thanks very much, Ms Andrews. I'll ask Mr Reeve to respond.
Yes, of course. I think as Mr Newnham alluded to earlier, we receive information from a large number of government departments and agencies. In some cases that may be issues that they've identified in the course of their work. In other instances, it is those departments and agencies that have been that have received an approach from an organisation that they consider perhaps should be registered under the scheme. We also regularly review media reporting to identify cases, in the public domain that appear as though they should be registered under the scheme. We receive inquiries or notifications from members of the public. And again, sort of from across government, from individuals within government as well, Ms Andrews. So we receive that information, I think, from quite a wide range of sources, through official channels and from members of the public, and through our own tracking of issues in public debate.
Okay. Can I ask then a specific question about ASIO and the Department of Home Affairs, given that ASIO is actually not part of the Department of Home Affairs, it's actually a separate agency. Would ASIO come directly to AGD in terms of making you aware of any particular issues, or do they, as a matter of course, put any information via the Department of Home Affairs?
Ms Andrews, in my experience, they are a range of agencies, including the ones you've mentioned, are present in various forums that are information sharing forums that do inform the sorts of investigations or preliminary investigations and investigations we might undertake under the scheme. So I don't know that I could say there's been a requirement for them to go direct or indirectly. I think that's been the case, that there's been, as I said, multiple agencies involved, including the ones you've mentioned.
So to go to the question that Senator Patterson was asking in terms of the number of individuals and also, I guess, by default, the FTEs within the administrative part of AGD that deals with this. In terms of step number 1, which is the identification process, if you actually looked at the number of people who were then involved in providing information, particularly in relation to aspects of this scheme, as in who may well be someone who needed to be assessed or an organisation that needed to be assessed, it would clearly be much wider than the number of people who are strictly involved in the administration. Because you would draw on. I guess I'm trying to say it's not just 8.2 FTE, there are others that provide information, and in terms of the administration that might be entirely correct, but in terms of the entire process for making sure that the assessments are conducted, all of that information,
yes,
it would go much wider.
Ms Andrews, I think that's a fair characterisation. I mean, for example, I'm not counted against the 8.2. I do attend meetings. I do have the benefit of information sharing with me that does inform then the conduct of the 8.2, and that's just one example. There'd be numerous examples then outside the department, whereas you say the information may in fact enter government through another entry point, but actually be relevant to our scheme. And the section, I think it's 52 and 53, very much go to the ways in which that information can be shared across those different frameworks between agencies. So your point, I think, is fair.
So I'm not necessarily convinced that FITS has failed. I actually think that, like with most bodies of work, and particularly with legislation, there are always opportunities to make it better. So I guess we can draw that from the information that you've already put to us.
And Ms Andrews, I might respond to that. Of course, I mean, I think we've been very proactive in offering suggestions for improvements to the scheme, and that ranges from reiterating the transparency sort of purpose of the scheme. It goes to amending the definition of foreign principal, which actually is at the heart of a fair bit of the resourcing issue that's been raised here today. We've talked about graduated compliance through various notices. We've mentioned, I hope, refining the obligations on the former cabinet members and designated office holders. We do think the exemptions actually could be tightened, particularly here mentioned in relation to charities, in relation to commercial or business pursuits, and equally statutory office holders who, I won't say ironically, but interestingly, if they are conducting activity in their personal capacity, that exemption still arguably stands, and we think that's a loophole that should be closed off. So, and I think, although it goes to a level of detail, there is actually improvements we can make to the transparency notices. And finally, some other more technical amendments. So that really is 7 categories that we think, in our experience of administering the scheme, would be beneficial for the original objectives that were envisaged by the Parliament at the time.
So it is, and this is my last question. So is it a fair characterisation to say that the FITS Act has not failed, but there are opportunities that exist for improvement?
Ms Andrews, I wouldn't necessarily offer a view, but what I would say is that within the parameters we're operating, we think we've done as well as we can, whether it comes to the Section 45 notices, the Section 46 notices, the transparency notices. We do think the uptake of engagement voluntarily by a big range of stakeholders goes exactly to what we would describe as the positive elements of that scheme. We do think the engagement across government has been a very strong feature of the nature of that, and we would always say this is a scheme intentionally nestled in a landscape of other frameworks. That's the absolute role for it. This is, at its heart, legitimate activity that we are seeking to make clear is under foreign influence, but they are the sorts of activities that governments worldwide engage in. So on multiple sort of indicators, we do think there's a lot of positive results from it. We do think there are improvements.
Okay, thank you.
Chair, do you mind if I jump in? I'll be very brief.
You go ahead, Deputy Chair.
Thanks, Chair. I'll be as brief as the witnesses allow me, so I'll ask you to keep your responses brief because we are running over time. The university sector was, I think it's fair to say, that came and gave evidence this morning, were quite exasperated by the lack of contact, the lack of, I suppose, consultation with them about the operation of the Act. And that I don't know if you heard them, but they certainly gave evidence that they were very frustrated and quite bewildered, I think is probably a better term, that no one from Attorney Generals or any of the security agencies had doubled back to them and said, okay, well, what you're doing now is in compliance with the Act. What do you say about that? Did your department double back and provide any assistance or advice to any of the universities?
Look, thanks very much, Deputy Chair. I would. It's obviously of concern if a stakeholder is concerned about the nature of the scheme and our engagement with them. I would offer that we are standard attendees at UFIT, the Foreign Interference Task Force for Universities, a bespoke model that we, in our view, consider works very well. And there's very good engagement with those universities, and we attend there and, of course, would be very open to concerns being raised there. I would, as a second point, offer that it wouldn't be necessarily a feature of the scheme that we would go to any stakeholder and say there's compliance, but what we would do is offer as much clarity and assistance as we can to anyone that would contact us, raise any concerns, ask questions about the nature of their activities and how it might apply under the scheme. That's at the heart of what we're seeking to do as the administrator. I would just note to Deputy Chair, of course, there are multiple frameworks in place. They were established at different times. They covered different things, and I understand that particularly the university sector is concerned about the wide range of the number of those frameworks and how much it applies to them. But if I could just offer for the committee's benefit, the FITS Act has actually had limited application to universities. To date, there have only been approximately 4 universities with related registrants since the scheme commenced.
That's part of their concern, is that Professor George Williams described it as effectively high maintenance, low return. High regulatory responsibilities on the part of the universities for very little return. So I think that's where they're getting frustrated.
Yeah, and Deputy Chair, look, I didn't see his testimony, and I can't say with clarity exactly what that was referred to. But what I would note is that the Act applies to influence activities undertaken by academics or universities, and the judgment was made that that was important. They are and can have strong and influential voices in policy debates.
Absolutely.
It may well be that it has limited application. People can make their own judgments about that.
Under the operation of the Act as it's currently worded.
Indeed.
Very quickly, I'm not sure if you're aware, but a week ago, Canada, on the 14th of February, made an announcement in relation to grant funding for universities. Are you aware of that announcement that they've made?
Deputy Chair, I vaguely, but can I just call on Mr Reeve to assist with your question, please?
It's not a trick question. I'll just read out quickly. Grant applications that involve conducting research in a sensitive research area will not be funded if any of the researchers working on the project are affiliated with a university, research institute or laboratory connected to military, national defence or state security entities of foreign state actors that pose a risk to our national security. This enhanced policy will be implemented rapidly in close consultation with our departments. Would you describe that as more dealing with foreign interference or foreign influence?
I think, as I understand the announcement, Deputy Chair, I would say that probably relates more to the nature of the arrangements between the Canadian university or the Canadian researchers and counterparts. I think depending on the actual activities that are then undertaken, you could probably go in either direction.
What they're basically saying is that no funding will be provided to a university where anybody involved in that particular program has got any involvement with any military or any authoritarian organisation or government department. That's how I read it.
Yeah.
Have we got anything like that?
Deputy Chair, I don't know that I can answer that.
Happy for you to take it on notice.
Indeed we might, because I want to be careful about the nature of the Canadian, exactly what was put in.
No, that's fair enough. Can I get you to take that on notice and you are providing material to us, and just come back to us as to whether you think that that's something that we should be looking at as well if we don't have an analogous arrangement.
Yeah, Deputy Chair, and I'm conscious I've taken on notice. I mean, I would offer, of course, there are clear definitions in the FITS about what is a registrable activity, lobbying, activities for the purpose of political or government influence. That's quite specific. Of course, if you're a cabinet member, former cabinet member or designated office holder, that's automatic. But that definition is quite specific. It sits, as I said, alongside the CFI related obligations in Home Affairs. I just, we would have to, in that context, look at the sorts of things that Canada has proposed. But we do feel like the combination of frameworks that currently exist do cross the waterfront, but we would have to look at what the Canadian suggestions is regarding.
I think it's very important that we don't close our eyes and think that Australia, to the extent that we are a forerunner in many of these things, can't learn from our cousins across the ways.
Thanks.
Last question, and it'll be a very quick response, I'm sure. In your second submission, the Attorney General's Department changed its position in relation to infringement notices.
Yes.
Why did you do that?
I'm going to ask Mr. Reeve to answer that, if that's okay, Deputy Chair. Yeah.
Thank you, Deputy Chair. Look, I think, as we've set out in our submission, infringement notices obviously are a form of graduated enforcement mechanism. They would be available at a lower level than a criminal prosecution. But they are typically used in circumstances where the officer, the official imposing the infringement notice, can have a very, very high degree of certainty that the relevant offence has been committed. I don't want to trivialise the matter, but parking tickets or the like are the obvious low-level one where you can have very great certainty that a person has infringed and then impose a notice on them. I think it is fair to say that the offences under the FITS Act are a little bit more complex than that, and in particular they do turn on the mental state of the person who is either failed to register or failed to comply with their obligations under the scheme. It does require them to either be reckless or to have intended to do so. And the existence of that mental state is something that I think it would be probably inappropriate for an infringement notice to be used in relation to. It would be difficult for an officer to have that level of certainty without having undertaken a full investigation.
Thanks. Very good. Good answer. Thanks, Chair.
Thank you very much, Deputy Chair. I think that brings us to a conclusion. I want to thank you all for your attendance today. If you have been asked to provide any additional information of answers to questions on notice, and I note there were quite a few of those, the Secretariat will be in touch regarding timeframes for providing that to the committee. You will be sent a copy of the transcript of your evidence once it is available in the coming week, and you will have an opportunity to request corrections to transcription errors. I want to thank all of you for attending today and sharing your insights. There being no further witnesses, I declare this public hearing closed. Thank you very much, colleagues.
Thank you, Chair.
Thanks, colleagues.